emergency.
What is the urgency?
Urgency was the fund from the central government has been allocated to the state government for the ward in Alakanti. There are some guidelines laid down so that the money could be distributed as per the guidelines. Now, keeping a go by to all the guidelines, the money is being placed in a different place. And 28 is the day for the 20.
Lordship, I beg to mention item 3. We were given an opportunity to file an additional affidavit, which was filed yesterday. The affidavit may be called for.
Particular old matter, 2014 matter. If it any date for it.
2014 matter.
Sure.
It's for what?
For admission.
Okay.
So last listed on 9/11/2013. 23.
It was listed.
Just listed.
Okay. Bench 4, bench 5.
5.
Monday.
I beg to mention the listing. What if this matter was listed or yesterday, but due to paucity of time, matter did not date. So it may come up on 29th.
Okay. Why it did not reach? I know that why it was item number.
It was 46.
Huh?
46 item.
And you wanted there was is there any interim order? Okay. We'll have it on Monday on 4th of December.
Okay.
Lordship, I beg to mention the listing of one pending repetitive matter. Lordship, on 1st of December.
Why?
The matter is pertaining to non-payment of contractual bill amount.
So contractual bill is of which year? 2012-13 must be.
2022.
22. Then you can wait next year.
Any date in the month of December.
Okay. 11th of December.
Lordship, I beg to mention item number 10. Yesterday, Lordship, we have filed affidavit in reply. Affidavit 50.
Call him.
Lordship, I beg to mention for listing of a case. The case was related to DC office Kamrup. The area rent of a car, part payment was released, but the full payment was not released yet. The last
Payment of?
Full payment of a car rent.
Car rent, hiring.
Yes.
Okay.
On the last month, respondent took time.
Oh, very well. Okay, next week. Wednesday market.
Item number 1 top of the list. Before I trouble your Lordship with the facts, the Lordship would kindly take the Act matter. Let us refer to 2 provisions.
Electricity Act.
Yes.
Yes.
First, my lord will kindly come to page 126.
Section.
Yes.
Yes.
If on an inspection of any place or premises or after inspection of the equipment, gadgets, machines, devices found connected or used, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or any person benefited by such use. The order of provisional assessment shall be served upon the person in occupation or in possession or in charge of the place or premises in such manner as may be prescribed. The person on whom the order has been served under subsection 2 shall file objection, if any, against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity to such person, pass final order of assessment within 30 days. So, my lord, against this order, there is a provision of appeal under 127. So, why I have referred to this provision, my lord? Section 127 by per se, it does not give any power of search and seizure. That power is derived from section 135. So therefore, what I respect now, what is unauthorized use of electricity, that is defined. Now, my humble submission is, my lord, in this case, perhaps the matter falls appropriately under section 135, where it as in D, subsection D clearly says, my lord, use of electricity to a tempered meter. Now, if we go by the substance of the allegation, if at all it is correct, then it's a case of use of electricity to a tempered meter. That is why they, my lord, they changed the meter. It's a different matter what followed thereafter. Now, if your lordship kindly comes to 135,
But it will also come under, tempered meter will come under unauthorized use of electricity.
no, therefore, if we read it harmoniously also, my lord, end of the day, the power of seizure flows from 135, subsection 2B. The power of seizure doesn't follow from 126.
No, there's no,
Yes.
that is understood.
Yes.
But the judgment of the Supreme Court in that case, what is the name of the judgment? Where it was purposive interpretation was given to 126, read with 135.
Yes.
What was that judgment?
West Bengal State Electricity Board.
Yes.
Sitaram Rice Mills.
Sitaram, right.
Perhaps I have not read the judgment, my lord.
Because that is the main judgment
Yes.
on 126.
Yes. No, therefore, my humble submission is, my lord. Why I'm
There-
saying so,
Hmm.
I'm trying to find fault with the seizure procedure. That's why, my lord, I have taken your lordship to the provision of.
Because if I remember the judgment, it says that 135 is a power which has been given. But irrespective of 135 also, the power is still there with the assessing
Yes.
officer to do under 126.
Yes, that I'm not disputing.
So,
So
if
it's
there
a
is
complementary of each other, my.
it is complementary, but the authorities may not go further to impose the penalty for theft under 135, but they may go for assessment under 126. That is what is the ambit of Sitaram.
Okay. No, my lord, that does not, affect my projection, my lord. I have referred to these two provision to show the power of seizure flows from 135.
Yes.
It does not flow from 120, only for that limited purpose. Now, my lord, let us come to the facts of the. Now, I have already referred, my lord, under subsection 4 of 135. In matters of seizure, they are to follow the procedure prescribed in CRP.
Yeah.
That is section 100, subsection 4. And my lord, their own guidelines also.
Yes.
Your lordship would kindly come to 7.5. Theft of electricity.
This one?
Yes. Assam Electricity Regulatory Commission notification regulation 2016.
7.5. Yes.
The action that amounts to theft of electricity and conviction for such act as specified under subsection 1 of section 135 of the Act, and action on part of licensee in case of detection of theft of electricity as specified in so and so. Then kindly come to 7.5.2. Inspection, search, seizure. Now, what the officer is defined A. Please come to D, my lord. The provisions of the Code of Criminal Procedure 1973 relating to search and seizure shall apply in case of search and seizure mentioned above as specified under subsection 4 of section 130. So even their own regulation also, my lord, says that the provisions of section 100 subsection 4 CRPC will apply. Now, what has happened in this case, I have already indicated the other day, my lord. The meter was replaced in my absence on 13/6/2016. Thereafter, my lord, sometimes in 2019, almost after 3 years, I was asked to be present before a team where my lord, the meter would be verified. Now, based on that, my lord, the impugned action has been taken. So, in the meantime, a provisional bill was given to us, my lord. Then when I wanted to file an appeal, they insisted on pre-deposit. Then we approached.
No. You filed objection to the provisional assessment or not?
Yes.
You filed objection.
Yes. Now,
Under 126.3.
so naturally that will be under 126.3. Now, if your lordship will kindly, I just want to place the facts, my lord.
Show me your objection under 126.3.
I think it should be, I think page 28, my lord. My lord, to be honest, it was not in the form of an objection. What had happened, we filed an appeal, man. We filed an appeal. And
Page
while,
28 is an appeal.
yes,
You went under 127
Yes.
against the provisional
Yes.
assessment. Meaning thereby 126.3 has not been till completed.
no, it looks like,
Because that on that day also I asked you that specific question.
yes.
Because you have a right to file your objection under
In fact,
126.
against provisional bill also we can file.
Against that, then only it will be made final. And if I remember, 127 does not say any appeal arises under 120.
Against the final bill.
Against
Against
only
the final order, against the final order under 126.3.
Any person aggrieved by the final order made under section. So this is under only 126. But whether the final bill was made, Mr. Pathak,
Yes, it
Where
is
is
there in my affidavit.
Huh?
It is there in my,
for me,
the final,
where is your notice about the provisional bill and asking him
the
to?
provisional assessment bill, your lordship will find at page number 109.
Yes.
Page 22 of the writ petition.
Physical
I beg your
verification
pardon, 111, your lordship is the bill. 109 is the assessment order.
22, page 22 of the writ.
So this is 33 lakh.
109 is the order, 111 is the bill.
And when you forward it,
Yes.
where is your forwarding?
Page 24 of the writ petition. 24, and actually,
Date of inspection.
Order at page 24 is the final
yes,
assessment order.
yes. Even provisional bill it is also 19.
And you have paid 50%.
My lord, initially, I think we paid some amount, and pursuant to the order of this honorable court, we also paid some amount. I think in all, my lord, 25% was paid while my lord filing the appeal, and before this honorable court, my lord, we paid another 3 lakhs on by the order dated 8/2/21.
Mr. Pathak, was the report prepared after the inspection?
Lordship, the inspection first, it was conducted on 7/6/2016. The report is at page number 99 of the affidavit in opposition.
Page 99
99
of the
affidavit in opposition. Annexure B. Type copy is at page 97.
This is the inspection report.
On 7/6.
This inspection report was prepared when?
On 7/6/2016.
7/6/2016.
And the meter was taken away on 13/6. That report is at 102. So sealed and taken out.
And when was that meter tested?
The meter was tested, Your Lordship.
2019 January.
Yes.
Why?
Lordship, we were writing to them to be present in the testing. We were writing to them.
For 3 years.
Yes, Your Lordship, letters are on record. We had letters are on record
Understood. For 3 years.
because we wanted the testing process to be transparent. So they did not appear. So finally we went ahead with the testing in 2009. The multiple letters are there. But the testing report and the inspection report will reveal, Your Lordship, the seals which were applied, Your Lordship, on the day of the inspection and the meter was sealed. And those were opened only on the day of testing. The seal numbers are there. I checked.
The sealing was done in presence of the petitioners.
He was present. We made a statement on affidavit. He was present, but he refused to sign.
And where is the report shall be signed by the assessing officer, each of the inspection members, and by so this report, which is given under 7.4.1 E
Okay.
is the inspection report.
The report at page numbers, the inspection report, your lordship, is the report at page number 99.
Yeah.
The one done on 7/6/2016. The see the one at page number 102 is the report of sealing and replacement of the meter. The inspection report, which led to the proceedings, your lordship, is the one at page number 99. The inspection done on 7/6/2016. The remarks say, your lordship, that's I'm reading from page number 98.
I
As
mean,
per- as per letter number, so inspected the metering HTC system of the premises and found that the metering seals of the consumer are not in proper order. CMRI data are downloaded at site. Suspected the meter has been tampered, which is to be tested in laboratory in the presence of the consumer stroke representative after replacing the existing tampered meter with a new one. The
now
SG
tell me, once you carry out that inspection,
Okay.
as per 126, because without an inspection, you can't have a provisional assessment. Can you have the provisional assessment at any point of time?
lordship, the fact that the meter has been tampered with was conclusively established only in 2019 after the testing was done. Because before that we were only suspecting. The report itself says suspected that the meter has been tampered with. It was only conclusively established when the laboratory testing of the meter was done, and we found that foreign circuits have been implanted inside the meter. Only then it was established. Before that, we only had a suspicion.
But if you see 7.4.2,
Perhaps this code would not be applicable to these proceedings, your lordship, because this supply code, your lordship, it came into force on it was notified on 18th of November 2017, and the inspection was done on 7/6/2016. So the earlier code would be applicable.
it is the earlier.
I have.
But you say that the provisional assessment was not made under this code.
It was done under the earlier code because the genesis of the entire assessment proceedings is the inspection report of 7/6/2016. So perhaps this code would be applicable.
Where is the AR for provisional assessment?
It would be under, your lordship. It would be at page number 1220. Interference with so it's from 2007, 2004 amended.
Which is the AR of provisional assessment?
It 5.8.4, your lordship. There is just 5.8.4 at page 1221. And this is this is what the code said at that point of time, my lord.
But here is a case of malpractice. It doesn't say anything about unauthorized use of electricity. The term which is being used out here is unauthorized supply of electricity.
Lordship.
How is it? How
Lordship.
do, how do you equate this thing with or relate this thing with 126? Taking into account here it says about compensation. It doesn't say it about the provisional bill, which is the mandate under 126 too.
Yes, this in fact, this is precisely why this code was replaced, Your Lordship.
So if we have to go, if you have done this,
Lordship.
and precisely for that the code was replaced,
I mean,
then
this is one
obviously
of the
the
one of the
manner
reasons-
in which is wrong.
one of the reasons why the code was replaced, Your Lordship.
But the one of the reason is there.
But the procedure with section 126, Your Lordship.
No, why I'm saying is, if you see 7.4.2,
Yes, Your Lordship.
it says that if an assessing officer suspects the unauthorized use of electricity has taken place,
Lordship.
he shall make provisional assessment and serve the assessment order to the consumer.
Lordship.
Meaning thereby, it is on the basis of the suspect,
Lordship.
not on the basis of finality.
Yes, Your Lord. Yes, Your Lord.
So that is why it has taken 3 years. Because you suspected, as per the inspection report.
Yes, as per the inspection report, we suspected.
Then,
But to make the assessment, Your Lordship, perhaps we have to come to a subjective finding that what has been the loss caused to us, Your Lordship. Because 126 says,
finally come to here, 126.1. If in an inspection of area or after inspection of so and so device found connected or used, or after inspection or maintained by any person, the assessing officer comes to a conclusion
yes,
that such person is indulging in unauthorized use of electricity,
Lordship.
he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such use. The order shall be served upon the person in occupation or possession or in charge of the place or the person on whom such an order has been served shall be entitled to file objection, if any, against the provisional assessment before whom, and after affording an opportunity of hearing, shall pass. Now let us see that sitaram judgment. You have a copy of it?
Lordship, I do not have it right now.
Why? You know, this is the item in the first list, and this is his specific submission. That it may be a case under 135, and if it is a case under 135, you can't go under 126. That is his specific submission. And if it is under 135 and you want to apply 135 and then to 126, then obviously you are.
I have it. In the meantime, Your Lordship, I have the judgments of the coordinate bench of this honorable court where this issue was decided, framed and decided. So in the Shiva lawyers matter, 2021 4 GLR 558. By relying on those judgments. The issues, Your Lordship will find that paragraph number 7.
21 14. No, Kela. 21 14.
Seven A.
7A. Your Lordship.
This was appealed.
This was appealed and upheld. Your
Yes, what does he say?
The conclusion Your Lordship will find at paragraph number 4, first at paragraph number 14, and then 21 and 22. paragraph number 21 and 22, the conclusion is there of that particular issue. By relying on Sitaram.
This is which judgment, paragraph 19, which has been referred to, is that judgment of Sitaram.
Yes, Your Lordship. The respondent is Sitaram. South Court.
And here, Mr. Chaudhary's submission is very specific. He says, if you are to seize, and on the basis of the seizure, you have taken up, you have found that there has been a tampering. If the seizure is not done as per the provisions of 135(4), would you be able to assess on the basis of that seizure? Because that is the tampering, because you could not conclude or decide that there was a unauthorized use of electricity till the seizure, till the meter in question was found to be tempered. But for getting that, or for making that, or coming to that finality or conclusion, because you have to conclude,
Yes.
it is based upon a seizure, which is, however, not in terms with 135(4). How do you answer to that? That's your exact submission.
I'm obliged, my lord. In fact, that is what at para 23 of the Supreme Court also says. At that Supreme Court judgment which the lordship referred,
Which one?
that my lord Sitaram,
Oh, where is that?
para 23, by applying these principles to the provisions of this case requiring judicial interpretation, we find no difficulty in stating that provisions of section 126 of the
You are
2003
referring to
Act,
paragraph 20?
3, my lord.
20.
By applying these principles to the provisions of this case requiring judicial interpretation, we find no difficulty in stating that the provisions of section 126 of the 2003 Act should be read with other provisions, the regulation in force, and they should be so interpreted as to achieve the aim of workability of the enactment as a whole, while giving its purposive interpretation in preference to textual interpretation. So, my lord, my humble submission is you could not arrive at a finality based on your inspection. Therefore, my lord, you yourself felt that there is a necessity to come to a finality based on some objective material. That is why, my lord, there was a seizure and followed by, my lord, what was done in first part of 2019. Only thereafter they come to the conclusion that it's a case of tampering.
Kindly come to paragraph 28 and 29.
Yes, my lord. Precisely, yes. Section, of course, section 135 of the Act deals with an offense of theft of electricity and penalty that can be imposed for such theft. This squarely falls within the dimension of criminal jurisprudence, and mens rea is one of the relevant factors fighting out the case of the theft. On the contrary, section 126 of the Act does not speak of any criminal intendment, and primarily its action and remedy available under the civil law. It does not have features or elements which are traceable to a criminal concept of mens rea. Thus, it would be clear that the expression unauthorized use of electricity under section 126 of the Act deals with the case of unauthorized use, even in the absence of intention. These cases would certainly be different from the cases where there is dishonest abstraction of electricity by of methods enlisted under section 135 of the 2003 Act. A clear example would be where a consumer has used excessive load as against the installed load simpliciter, and there is violation in terms of the conditions of supply. Then the case would fall under section 126 of the Act of 2003. On the other hand, where a consumer by means and method as specified in section 135A to E of the Act has abstracted energy with dishonest intention without authorization, like providing for a direct connection, bypassing the install meter, the same would fall under section 135. My lord, it's true, my lord, who operates in different field. But my lord, 126 by itself does not provide the procedural safeguard. Possibly that is why Supreme Court said, my lord, in para 20, that there is a requirement of applying the purposive interpretation. Assuming, my lord.
No, Mr. Chaudhary, if you read the entire judgment,
Yes.
the Supreme Court goes on a different tangents and says,
Yes.
purposive interpretation is that to find out that and collect how much amount you can get it.
Yes. No, my lord, in
This is how it
fact,
is.
this judgment also went to the extent of saying the illustrations are only illustrative. It could be something, some other form also. Eventually, if a consumer, my lord, uses unauthorizedly, that cannot be confined to only the clauses A to E. It could include others also. Even this is a judgment where, my lord, most of the aspects has been dealt with. Now, why I refer to para 23, my lord, to support my contention that you must, read the provisions in such a manner that both are complementary of each other. That is an aspect which is not clearly gone into in this case. Now, for example, Lordship will kindly appreciate. Now, had it been a case only covered by 126, then why they resorted to seizure, my lord? They could not have, they should not have. By resorting to seizure.
Or does it cull down to a waste within a more smaller campus?
Yeah.
To the affair that the seizure being illegal.
Yes, therefore everything goes. That goes to the root of the matter. That is what my submission is, my.
But what do you say about the Constitution bench judgment wherein it says that the proceeds of an illegal seizure can very well be taken into account?
No. Yes, I'm coming to that. Now, my lord, as regarding admissibility of that with evidence following from that seizure, that by itself cannot be questioned. But, my lord, its credibility can certainly be gone. That's the settled proposition, my lord. Section 104 has been interpreted by the Honorable Supreme Court to mean that as far as admissibility of the evidence is concerned, that cannot be questioned. But when it comes to credibility of the witness, my lord, there is a question mark. Now, in this case, my lord, the report clearly says that metering seal is okay. If metering seal is okay, how can I resort to anything wrongdoing, my lord? Kindly come to the petition, my lord. Please come to page 100 of my learned friend's affidavit, my lord. Page 100, Annexure C. That's the report of inspection. On the left-hand side, bottom, no NB. Existing metering cabinet seal found okay. If the seal is okay, my lord, where is the question of I penetrating into the meter? And then the attending facts and circumstances, when the meter was opened in 2019, it had to be broken, my lord. That statement we have made in para 9 of the writ petition. It was in such a state that it had to be broken. If the seal was intact, where is the question of my lord tampering? Well, at the end of the day, lordship will apply the test as Supreme Court has applied in case of disciplinary proceeding. If there is some evidence, end of the matter. If I can establish that it's a case of no evidence, as in disciplinary proceeding, here also lordships will apply the same test. There is no evidence. What are the objective material to come to the conclusion that there was a
Mr. Chaudhary,
tampering?
kindly come to page 97.
Yes, madam.
Metering seal, cabinet seal
Okay.
found okay. Sealed by RCF for metering
Yes.
return.
Yes.
And M cover is equals to found broken. What
Ah.
is M cover?
Meter cover. Meter cover.
So metering seal is okay.
Okay.
So meter cover is
Cover is
Ah.
broken. So there is a, in every meter, your lordship, there is a meter which is sealed. And on top of the meter, there is a cover, your lordship. The cover was broken. It was
okay. Now, if the cover was broken,
But meter
why you have mentioned in your remarks? Kindly see it.
lordship.
Page 98.
Lordship.
Inspected the metering HT system of the and found that the metering seals of the consumers are not in proper order as stated above.
Because as per the supply code, the cabinet and the meter together form the metering system, your
Fantastic. Now kindly come to here. Page 100.
lordship.
Existing meter cabinet seal found okay. How is it? How do you explain both?
Lordship, because the lordship may kindly see the, on page 100 is a subsequent day on which the damaged meter was taken
No,
away
no.
for inspection.
Here it says existing meter.
Yes. Lordship, I'll just show. It says,
Kindly see the remarks.
yes, your lordship.
As per the inspection report so and so, HT metering done by replacing the existing. Existing means again that the
Lordship.
old one. Then how do you equate both?
Lordship, because what has happened on
Mr. Sharma, you have got those orders.
7/6/2016,
One lordship I have got.
You have got the other one, I think.
Lordship may kindly see on 7/6/2016, after the new seals were found to be broken, after the old seals were found to be broken, new seals were placed.
No.
Yes, your lordship.
You see here, NB existing meter cabinet seal found okay.
Yes.
Okay. Now what is the existing
Yes.
mean? It has been further explained here. As per the inspection report so and so, HT metering done by replacing the existing bracket
Yes.
suspected to be tempered.
Yes, your lordship.
Means existing is that
Intact. On 7/6, your lordship, once the old seal was found to be broken, we cannot leave the meter in open condition on 7/6. So the report of 7/6/2016 will reveal that we have placed new seals on that day, your lordship.
on
7/6/2016.
understood on 7/6 you have
Yes,
done
your
it.
lordship.
But that is why the existing word which you are using
Yes, your lordship.
is as regards the tempered one.
It refers to the seals placed on 7/6, your lordship.
No, it couldn't have been. It couldn't have been because why you are using as per the inspection report dated so and so, revised HT meter is done by replacing the existing
Existing meter.
existing suspected meter.
Meter.
Meaning existing is that existing which was there.
Which was found
Existing
intact.
because you are replacing the existing.
Lordship, I'll just try and explain. The cabinet seal was broken. The meter was suspected to be tampered. So on 7/6, the broken cabinet seal was replaced with a new seal. So the reference to a seal found intact in the report of 13/6 is to the new seal placed on 7/6, your lordship. And the meter, your lordship, because on 7/6, the remarks are that this meter should be taken away for laboratory testing. It refers to that. The meter existed at that stage. The meter was taken away for testing. The cabinet was resealed and that seal was open on 13/6 because it was a seal which you had
Then
placed
kindly
like
see the next line.
Lordship.
Existing damaged cabinet
lordship.
has also been replaced.
Yes, your lordship.
Meaning thereby the existing is again refers to that which was there,
Yes, your lordship.
has been replaced.
Lordship.
Now kindly see here existing meter cabinet found okay.
The existing meter cabinet,
This is a report of the inspection,
Lordship is reading from page number,
page 100, down
Page
below.
100.
It
Yes,
says
Your Lordship.
existing meter cabinet found okay.
the cabinet seal has been found okay, Your Lordship, because after replacing it, we have sealed it, Your Lordship. So on 13.6, it is definitely okay, because it's a new seal of 7.6. On 7.6, once it was found to be broken, we have resealed it. On 13.6, to replace the meter, it has to be opened, the seal has to be broken again. So the existing seal of 7.6 was okay, Your Lordship.
And where is the report?
The inspection report, Your Lordship.
Ah.
The laboratory testing is at page number 109, Your Lordship. It was done in the presence of the consumer. And Lordship, I'll just point out one thing, Your Lordship.
Yes, just one. So
The seals which were
section. And where, what is his objection or appeal filed
yes,
against which that order was passed?
yes,
This
filed
is
an
after
appeal and then a
complaint.
review also, Your Lordship.
It's okay. 22, 2019, I think this is
Yes.
prayer for consideration of the appeal.
Yes, Your Lordship.
Appeal is at page 42 of the writ petition.
No, not that appeal. Not that appeal. The objection, I think, is at page 28.
Yes,
And on the basis of which this
Yes.
order was passed.
Yes.
yes, yes.
Where is that? Where is his objection on the basis of which this order was passed on 8/2/2019?
So this is our objection, page 28.
Yes,
No,
that
no,
has been taken. as
No,
well.
no, page 28 is subsequent because this is after
It is on 22/19.
No, 22/2/19 is an appeal.
Yes,
I'm not on that. You see, the objection on the 126(3) must have been responded. Where is that? Because here he passes an order saying that after hearing this, page 24.
page 29, my lord.
No, 26 is the order.
26 is the
26 is the
Is the final
25,
assessment order.
24, 25, 26. This is the final order.
yes, sir.
26.
8/2/2019, whereby it says that I have given the provisional assessment bill after receipt of the notice. The consumer paid for providing reasonable time for preparation of appeal against the order dated so and so. That is the provisional bill
Sure.
or assessment order. The same was forwarded to the higher authority. The written statement submitted along with an appeal dated by the director so and so Iman, where the appellant tried to say that they did not commit any malpractice by tampering with the. Where is this one? The consumer statement, I think, is at page 26A.
Statement of respondent.
Perhaps there, no, there should be an appeal which has been filed on 6/2/2019. There is a reflection at page number 25.
Yes, yes, that
On
is what
six-
I'm.
Yes,
I
that
am-
is perhaps not on record. Your Lordship is that is not on record. On 6/2019, the consumer placed a written appeal to the undersigned as annexure 5.
My lord, I am instructed to submit. We did not file any objection. We straightway filed the appeal.
No. There it is mentioned here, na. Kindly see page 25, consumer statement.
Yes.
The written statement
submitted
submitted along with an appeal
by the
dated by the
director.
by the director so and so, wherein he stated so and so. Where is that document of 6/2/2019?
In fact, there is a reflection of that in the previous.
Honorable Secretary, written appeal to the undersigned. That is annexure 5. Record of record. Oh. In fact, it was perhaps on 6/2/19, my.
Hmm.
Not 5/2/19.
No, because this document is very relevant. Kindly come to page 26A.
6/2/19, my lord.
Page 26A. And kindly come to the statement of the respondent,
Yes, my lord.
where the consumer had signed it. Kindly come to D.
As per the meter installation report, the meter bearing installed and
No.
ceiling done by
As reported, the
as report-
objection made by the appellant under so and
which para, my lord? I'm sorry.
page 26A D.
B. As per meter installation report dated 18/11/2010, the meter bearing serial number so and so installed and all necessary sealing done by TNC personnel, and also mentioned in the report. The meter was new and laboratory tested as reported.
No, I'm saying D.
I'm sorry. As reported, the objection made by the appellant under point number D expressed that delay in laboratory physical testing was due to non-presentation from the appellant side due to some serious and other problem from their end, and also no such pressure was created. No, in fact, my lord, this is wrong. We have clearly stated in our reply, my lord. We are not served with any notice, my lord. We have denied their statement in the affidavit in opposition. In fact, my lord, at page 141, para 5, we have said, my lord, no, intimation was given to us.
Page 141,
my lord, para 5. That is statement made in paragraph 6 of the affidavit in opposition being misconceived, the petitioner denies the correctness of the same. It is humbly brought to the notice of this honorable court that letters dated 28/11/16 and 4/1/17 were never served upon the petitioner. Rather, on 14/6/16, the then managing director of the petitioner firm approached the concerned appellate office and served a letter of resentment stating inter alia the illegal arbitrary seizure of the matter in absence of the petitioner authorized representative. Further, after seizure of the meter, respondent slept over the matter for a long time, and on 7/12/17, the concerned appellate authority served a letter to the petitioner directing presence at the testing site for testing of the seized meter. It is also stated that petitioner responded to the letter clarifying the entire fact. Thereafter, petitioner again on so-and-so, the concerned authority served a notice asking the petitioner to remain present at so-and-so, where the seized meter was to be tested. Petitioner represented on so. But this is the actual position.
those documents which you are referring in that paragraph,
Yes.
they are not on record, however.
They are part of our affidavit. They are
So that document which he is saying, is clarifying his stand by the letter dated 14/12/2017. Because this court would like to know what was your actual objection to the provisional assessment. Because then only it would appear what have you taken? Many other things can be developed. But here is therefore the question is, but Mr. Chaudhary, one thing, if it is even an illegal seizure, you see, an illegal seizure cannot be used to the prejudice of a person accused of a crime.
Yes.
There's no law. The law is very clear.
Yes.
But an illegal seizure can be very much used for the purpose of proceeding against a person in a civil matter. That is again the law. That is why in income tax, it has been held by the Constitution that even if there is an illegal seizure, in fact, that brief.
The DRN and serial
My
lordship.
lord, admissibility is not an issue. What is an issue is the weight of the material,
Hmm?
weight of the evidence, credibility of the evidence. So admissibility is not enough. Even if there is violation in the procedure prescribed by the Supreme Court has said in so many, I have brought those judgments by that by itself, it can't be said it will not be admissible in evidence. But when it comes to, my lord, testing the weight of the evidence, then, my lord, the question comes about its, credibility. And kindly see the attending facts and circumstances. My lord, one most important fact in this case is para 9 of the writ petition. Please come to that, my lord. Para 9.
Yes.
That the petitioner begs to state that again on 11/1/19, the respondent authority served a notice directing the petitioner to remain present on 12/1/19 at Meherpur, Silsar, TNB lab where seized meter was to be tested. Accordingly, on 12/1/19, testing process was carried out nearly after 3 years of seizure of the meter, and for that said period, the meter was lying with the respondent authority. It is pertinent to mention here that concerned city wing of the respondent authorities who are expert in handling the meter could not open the meter unless broke the seized meter into several pieces. Thereafter, testing report was prepared, alleging inter meter is suspect. Kindly see the attending facts and circumstances. That's why I'm saying, please come to the credibility of this version. My lord, the meter was lying for 3 years at your premises, over which I have no control. Who knows what you have done to the meter? Why this procedural safeguard? To take care of those, situations. Can you see?
But the seal remained intact.
So, my lord, it could not be opened. It was, the whole meter was broken into pieces. And thereafter to come to a finding that it's a case of tempered metering, is it possible, my lord?
No, they are not saying that the meter has been tempered. No, this is not the case. They say that the cabinet of the meter was tempered.
Initially, our basis
the
of our
cabinet-
suspicion.
Even if I temper the cabinet of the meter, nothing happens, my lord. What my learned friend is saying is there is an outer cabinet.
That
there
is
a
the meter.
He says, as far as the outer cabinet is concerned, the seal is not intact, but the metering seal is intact.
Ah.
Then if metering seal is intact, where is the question of tempering? It is intact. And my lord, and coupled with that, please come to page 61. End of the matter, my lord, kindly see page 61 of the writ petition. Now, after the new meter was, if our intention was to, defraud the FPTCL by paying less amount, then after the new meter was installed, my lord, the consumption pattern should have gone up drastically. On the contrary, it has come down.
No, it has increased.
And what does tempering of a meter mean?
Yes.
Tampering of the meter means, your lordship, it is defined, your lordship,
Where?
in section 126.
Where?
So unauthorized use of electricity is different.
No.
Tampering per se is not different.
No, because
Temper-
another submission which has been now, the meter being intact, whether the tempering of a cabinet would amount to tempering with the meter.
Yeah.
No, not only the meter cabinet, your lordship, even the meter was tampered.
No, that is never your case.
It is our case, your lordship.
Where the meter has been tempered, see the
Yes.
inspection report.
Yes, your lordship. Lordship, on the day of the inspection, your lordship, on the day of the inspection, we found the meter cabinet to be tampered with. The seals are tampered. Then the meter, it was tested in the laboratory in the presence of the petitioner's representative. When the meter itself was opened, your lordship, we found 2 foreign circuits installed inside the meter. So the electricity reading is tampered with, your lordship. It was on the basis of that conclusion that the assessment under 126 was finally drawn up by the assessment office.
Not on the basis of the cabinet.
Because the cabinet led to
Cabinet
suspicion.
gave to you the suspect,
Suspect.
and thereupon on the basis thereof.
Yes.
Now, my lord, please come to page 18 of the writ petition for a moment.
And did you prepare a
there is
report? Did you prepare a report at the time of making the report because when the report was made or when you
Laboratory?
broke the thing, did you make a report?
Yes, it is at page number 109. This is the
09.
Yes. on 12/1/2019. Oh, 109 of the affidavit in opposition.
Of that 109. We put the meter and the terminal cover, which was put during withdrawal, were found okay, and during the meter, TT things are found in
Point number 4 would be relevant at the bottom of the page.
and they were present.
They were present. He has signed, your lord.
He has signed it on 12/1/2009.
It's present now, 12 I was not denying that. It's okay with it. Is that found okay? Question, we have found okay.
And Mr. Chaudhary, did you file any objection to this after signing it? Signing up to page 109?
Yes.
Where is that?
Objection in the form of appeal, my lord.
No. Against this 109,
No,
did you
perhaps
file?
not,
Because you
perhaps
have
not.
signed it out there,
Yes.
where it has been categorically held that there was a
Against that, my lord.
foreign
eventually,
objects.
Based on that, they submitted the bill. Then, my lord, we preferred an appeal. In the appeal, we have taken those.
Have you denied that there was nothing, or I was asked to sign out there?
Yes, my lord.
Where
Kindly
is
come to
that?
the appeal memo. That is at page number 40, appeal 42, my lord.
Yes.
Yes.
But you did not take that point in your objection to your
No,
provisional
kindly
bill?
come to page 45, my lord. Our ground.
Yeah.
For that, on 8/6/2016, the staff of appellant found a copy of inspection report said to have been carried out by the concerned APDCL staff of Bhadrapur Circular 7/6/16. On inquiry, it is learned that no authorized representatives of the appellant was told or present at the time of the, however, in the said inspection report, it is clearly stated that metering cabinet seal is found okay, sealed by so and so. But the said report also contains general remark, which is otherwise seems to be contradictory to the initial finding. The relevant portion of the report dated may be so and so. Meter cabinet seal found okay, so and so. As per letter, so and so, system of
No,
the
the answer to my query is at page 47.
yes. Yes,
Nine.
my lord. Para
Clause
9.
9.
For that, the appellant begs to state again that on so and so concerned department served a notice asking appellant to remain present on so and so, where the seized meter was to be tested. Appellant was represented on so and so and the testing process was carried out. It is for here that the concerned department who were experts in handling of the could not open the meter and broke the seal meter into several pieces, and a testing report was realizing inter alia meter is suspected to be tempered. Then without giving any opportunity to read over the report, get the report signed under threat to disconnect the electricity, etc. The appellant having no option to sign but to sign.
But Mr. Chaudhary, did you take this plea in your objection to your provisional assessment?
No, my lord, we didn't file any objection.
Because by the time the appeal has come,
yes,
it has come to within the thought process of many people.
no, my lord. Now, let us test my learned friend's argument that the cabinet seal was found to be tempered. That is not, my lord. It is not correct. Please come to 7/6 report at page 23 of the writ petition. They're contradicting themselves. Please come to my lord.
Yes, I've seen it.
Yes,
It says that the meter
page
is on. Meter is okay.
Meter cabinet is okay.
Okay. Cabinet.
Well, therefore, sometimes they are saying cabinet seal is not in order. Sometimes say the meter. The fact of the matter is, on following 7/6 inspection, the meter cabinet
No,
seal was
Mr.
found
Chaudhary,
okay.
you produced before me the 6-2
Ah.
annexed it.
Yes.
Produce that document.
Yes.
One aspect. of
Yes.
it.
Or you must have got on 6-2 because it is recorded in your
I'll get
assessment.
the entire record, your lord. from the-
Get me that 6-2 because you see, whatever else has happened at that point of time when the inspection was carried out, you found the cabinet was broken. Thereafter, it was again existing meter and all these things. But that cabinet broken was not the issue.
Ah.
It was on that was the basis of your suspect.
Suspicion.
You brought it out here.
Yes.
After bringing it out here, where you broke it in front of the representative, and then you found one red and blue line out there, foreign subjects, and it is on the basis of which it is your case that it is a case of tampering. Now, he has said in paragraph number 9 of his ER that you see, I was not asked to, without allowing me to see it, I have signed it.
Under duress.
But the question is as to whether he took that aspect at that point of time, at any point of time prior to the final bill being prepared.
Yes.
Because on the basis of that, you have prepared the provisional assessment and given him an opportunity.
Yes.
He took the opportunity on 6/2.
6.
And thereupon the provisional assessment was made,
Yes.
the final assessment.
Final assessment.
Thereupon he has filed an appeal, it's a different thing. But did he take that issue at that point of time?
I'll
Because otherwise signing out there has some implications.
I'll
Okay,
get-
when?
1 week's time, your lordship, records have to come from Sipsagar,
One.
no, from Karimganj.
This court, upon hearing the learned counsels for the parties, and more particularly taking into account the physical verification and testing report, the testing report dated
12/1/2009.
12/1/2019, which have been signed by the officials of the respondent APDCL as well as the petitioner, one of the directors of the petitioner, is of the opinion as to whether would like to be apprised as to whether the petitioner at any point of time prior to the preparation of the final assessment bill on when 8/2/2019
8/2019.
have raised any issue pertaining to that the petitioner was asked to sign on the report without permitting the petitioner to have a look at the said report. It appears from the final assessment order dated 8/2019 that there is a reference being made to a communication dated 6/2019 filed by the petitioner. For the purpose of perusing the said aspect of the matter, the records pertaining to the assessments so carried out in respect to the petitioner would be required. This was matter again on 19th of December 2023, on which date Mr. K.P. Pathak, the learned standing counsel appearing on behalf of the APDCL, shall ensure that the said records are produced. Interim order passed earlier shall continue. Again, right, okay.
For supplementary.
Next matter. Tell me, what is this MDI meter for?
Your lordship, the MDI meter,
I don't understand what the Supreme Court has stated. How can you find the connected load? You can't, MDI meter can never say what is the connected load. A connected load can only be seen on the basis of the connection, whatever is connected to the license line of the distributor.
yes,
Nothing more than that, isn't it?
lordship, there is another aspect that when the proceedings the assessment proceedings were taking place, the amendment on which the petitioner is relying, your lordship, that amendment was not in force. It came in later.
Which one? MDA meter?
Yes.
No, my lord, 7.4.
I have the gazette notification with me today. It was notified later on.
Yes, my lord. that
After the
provision,
proceedings were complete.
Yesterday, I have pointed out that 7.4.2 Roman 3B, that was come into force later on, my lord. That's why I have not placed it earlier, my lord. Later on for clearance of my submission, my lord. That's why, my lord.
Then you don't have a case.
My lord, the metering system has recorded, my lord. I want to show one bill, my lord, where it has mentioned, my lord, the recorded demand, maximum demand, and billing demand, my lord.
Recorded demand, obviously,
Yes,
the meter can show. There's no quarrel with that. What is the use? What is the present use? That the meter can very well show. What is being said? What is the connected load? How can it show? Taking into account that the connected load is on the basis of the same being installed.
Cannot.
yes, my lord.
So under such a connected load cannot be done. And if the connected load, although in that judgment where Justice Arun Mishra has said that can be found out, but in my opinion, it cannot be because it will depend upon how can the meter record that another switch has been put. It is impossible. So what is connected load as defined out here would only mean those machineries which are connected to the distributor's license line. That's all. That switch, that fan, and your fan is connected, but not input to you.
Yes, my lord.
Something like
My lord, my contention is different from that, my lord.
Huh?
My contention is different from that. My contention is that consumption to give extra stress to the mains, my lord. Because
No,
yes,
can you use beyond the connected load?
yes, my lord.
No, you cannot.
Yes, my lord. I cannot. That
You
is correct,
cannot.
my lord. I
You cannot use. And that is what that day I found out one judgment. Oh, it is here. In this sitaram only it is mentioned.
yes.
That judgment, I got case to take it up. Sitaram it has been mentioned.
Yes, my lord.
And
yesterday-
also the judgment of, I think, in Shiv alloys.
Shiva.
There also it is mentioned that if you use it beyond the connected load, it will come within the ambit of unauthorized. I'm coming in 5 minutes.
And the MD maximum demand index is there, my lord, in the bill raised in each and every bill period, my lord.
Hmm?
Bill period. One of the bill, my lord, in which month the
So
inspection
your
was done,
submission
my lord.
is, I may have a 20 kilowatt capacity connected load sanction, but I can install machinery, connect it to the line of the distributor. But if I don't use it, then there would not be unauthorized use of electricity.
Yes, under section 126, my lord. My contention is that, my lord.
Under
26 of the, my lord, in the month of May 2018, the inspection was done. In that month, my lord, it was recorded T34 only, my lord, maximum. My lord, the sitaram Fishery mill case, my lord, it is stated, my lord, the cases of excess load consumption, then the connected to come.
Where?
My lord, paragraph 87
Of?
sitaram Fishery mill judgment, my lord, reported in 2022. That is, I think it's in record, my lord, yesterday I have submitted.
Paragraph?
Last page, my lord, paragraph 87.
Hmm.
In subpara 1, it stated, wherever the consumer commits the breach of the terms of the agreement, regulations, and the provisions of the Act by consuming electricity in excess of the sanction and connected load.
such consumer would be in blame and under liability within the ambit and scope of Section 126 of 2003 Act. Next, my lord, the expression unauthorized use of electricity means as appearing in Section 126 of the Act is an expression of wider connotation and has to be construed purposively in contrast to contractual interpretation while keeping in mind the object and purpose of the Act. The cases of excess load consumption and the connected load inter alia would fall under explanation B4 to the Section 156 of 2010. That's
Now
why I
tell
say
me,
again,
whether in the meter,
Yes.
if we go as per what you are saying, in a meter, at some time, if you have your machine is connected to there, you may put it to use. And if you use it, at some point of time, may even go to 697. But it is when inspection is carried out, it may not show 697 on the day when you switch off all other appliances.
Yes.
Then in that case, at the time of inspection, it is not there. It is not shown in the meter. Then in that case, it would not be an unauthorized use of electricity.
Yes, my lord, because if I use it in excess to the connected load or contracted load, then it will record in the MDR.
No, would it record at one point of time also it has
Yes,
been used?
my lord.
No. Would it remain
lord,
there?
It interpreted in the 1995 judgment, my lord, by the Apex Court, my lord, which was relied by the Bihar Rollers Mill, my lord, later on in the 2016 judgment case that I have relied on, my lord.
काली के तो बस judgment असेल. Then what is the purpose of having a connected load, sanction connected? If I can use at my will.
My lord, that can be considered in case of healthy consumers and who have not
काली में judgment की तो मैं कुछ नहीं खुद बोल. Proof की judgment की तो मैं नहीं.
my lord, I have another copy.
Yet I'll not away only for a they do it. Yes, where is it?
1995 486 between.
Which paragraph you are referring
My
to?
lord, I am referring to the paragraph 10.
3.
10.
10.
Here, my lord, it is necessary to elaborate what does the expression maximum demand mean and signify. In the case of our consumers and large-scale consumers, the electricity board all over the country generally adopt a two-part levy system. One part is called the maximum demand charges and the other part consumption charges. Every such consumer is provided with 2 meters. One is called the Trivector meter and the other is the normal meter, which records the total quantity of energy consumed over a given period, which is ordinarily a month. The meter, which records the total consumption, requires no explanation or elaboration since we are all aware of it. It is the other meter which requires some explanation. Now, every large-scale consumer knows the amount of energy required by him and requests for it from the board. If the board agrees to supply that or any other particular amount of energy, it makes necessary enhancements. Therefore, by laying the lines to the extent necessary and installing other requisite equipment, it is obvious that if a factory uses energy at a particular level load, and for a particular period, it consumes a particular quantity of energy. The Trivector meter records the highest level load at which the energy is drawn over any 30 minutes period in a month, while the other meter records the total consumptions of energy in unit in the month. Let us, hello, this part is relevant to me. This statement,
Let us read it.
yes, my lord.
Let us take the case of the respondent to illustrate the point.
Let us take the case of the respondent to illustrate a point. The maximum demand in his case is up to, but not exceeding 7778 kVA. What is his requirement? In the normal time, he is entitled to draw energy at that level load. That is his maximum demand under the agreement, but he may not always do so. Say, in a given month, he draws energy at 6000 kVA level only. Even then, he has to pay the minimum charges as stipulated in the agreement, but if he draws and consumes energy exceeding 80% of the energy, he pays demand and energy charges for what he utilizes. Now, let us notice how the Trivector meter, that is the meter which records the maximum demand, works. The meter is so designed that it only records the maximum demand level at which energy is drawn over any 30 minutes period in a month. It only goes forward, but never goes back until it is put back manually. To be more precise, suppose the respondent has drawn energy at 7770 kVA for a 30-minute period. On the first day of the month, the meter will record that figure and will stay there even if the respondent consumes at 7000 or lesser kVA level during the rest of the month. From these circumstances, however, one cannot jump to the conclusion that it is an arbitrary way of levying consumption charges. Normally speaking, a factory utilizes energy at a broadly constant level, maybe on certain occasions, whether on account of breakdowns, strikes, or shutdowns, or for other reasons, the factory may not utilize energy at the requisite level over certain periods. But these are exceptions. Every factory accepts to work normally. So, does the electricity board expect and accordingly produces energy required by the factory and keeps it in readiness for the factory. Keeping it ready on tap, so to speak, as already emphasized, electricity once generated cannot be stored for future use. This is the reason and the justification for the demand charges and the manner of charging for it. There is yet another justification for this type of levy, and it is this: demand charges and consumption charges are intended to defray different items. Broadly speaking, while demand charges are meant to defray the capital cost, consumption charges are supposed to meet the running charges. Every electricity board requires machinery, plant, equipment, substations, transmission line, and so on, all of which requires a huge capital outlay. The board, like any other corporation, has to raise funds for the purpose, which means it has to obtain loans. The loans have to be repaid and with interest. Provision has to be made for depreciation of machinery, equipment, and buildings, plants, machineries, stations, and transmission lines have to be maintained, all of which require a huge sum. It is to meet the capital outlay that demand charges are levied and collected, whereas the consumption charges are levied and collected to meet the running charges.
So you mean to say that there are two types of meters. One is the normal meter, which records the charges, and the other is the Trivector meter. Trivector meter records the maximum use at any given point of time. And thereupon, if the use is less also, that recording which is
Remains-
there
remains.
remains. And in your case, you had a Trivector meter. And there, the Trivector meter did not show 697
Yes.
or any amount. It was within this.
Yes.
And this aspect of the matter was not taken into consideration.
Yes, sir.
That is your case.
That is my,
You had a Trivector meter.
yes, my lord. Because I am HT consumer, my lord, all the HT consumers equipped with MDI meter.
MDI meter.
Yes, sir.
MDI meter is a Trivector meter.
Yes.
Which will show the maximum at
Yes.
any point of time
Any point of time.
for during that period.
My lord, it
Means
remains
how does it change thereafter? Or
manual, it have to change by manual use, my lord. When the meter reader takes the meter reading, my lord, at that time, he puts it to
again resets it.
yes,
Resets it
Reset.
to again so that for the next period it will be again shown what is the peak load.
Yes.
That is it.
that is,
And in your case, what were you showing? Some document?
yes, my lord, I want to show the record of MDI, my lord. Yes. Yes.
Yes. Connected load, contracted demand.
Yes.
Contract demand is the connected that one.
500, my lord.
Where is that book? एक किताबখন ক'ত গ'লে? এই কিতাপখন আছে ন ইয়াত? এই গ'ল পাই। Contracted demand contracted demand or the contract demand means the maximum demand in KVA agreed to be supplied by the licensee and indicated in the license agreement. Contract demand. So your contract demand was 412.
500.
No. What is contract demand?
Yes, my lord.
What is the definition of contract demand?
My lord, it given
Contract demand means the maximum demand in KVA agreed to be supplied by the licensee and indicated in the agreement executed between the licensee and the consumer. In case no agreement is made, the connected load will be provisionally treated as the contract demand till the agreement is made.
yes, sir.
Now here the connected load in that document has been shown as 500 kW.
As per our agreement, it is the 412 is there, my lord.
Your document shows
Yes, ma'am.
500.
Yes.
And what is this contract demand? Contract demand is the demand which they agree
Yeah,
to give
to
it to you.
supply, my lord.
So you were asked to be, you were to be given 412
Yes, my lord.
and you connected 500,
617.
670 left, huh?
not this, in this document.
Yes, my lord. Here, my lord, that MD sold, my lord.
Where
What
is
I have
MD?
maximum use, my lord.
Where is MD?
MD, my lord, I have marked, my lord, highlighted by,
MD KVA
yes, sir.
shows 334.
Yes.
And the contract demand is 412.
Yes.
Okay. And what was the your bill during that period? This is for that period.
Yes, my lord. That period means, my lord, that the month, for that month.
No, when the inspection was carried out.
Inspection was carried out on 29th of May, my lord, 2018.
Okay, so this was during this period.
Yes, my lord.
So here it was shown as 334.
Yes, my lord.
So that is the maximum you
That
have
is the
used.
maximum use. Maximum load given.
So this is MD is the trivectomy.
Yes, ma'am.
Till it is reset, it again
Remains same
remains the same for that month or till that period.
till that period. Until manually
Reset.
reset.
Yes, what do you say?
Okay, firstly, these are grounds taken for the first time in the writ petition, Your Lordship. Yes, the appeal he had preferred before the appellate authority, that is there on record. He has not taken this ground. Secondly, Your Lordship, the judgment that my learned friend is relying upon, that was passed under the old Electricity Act. Under the new Act, Your Lordship, when one section 126 has come in, after the inspection of the premises,
No, is the MDI meter a Trivector meter?
Lordship, I do not, because the word I did not, the instruction which I have, Your Lordship, is that the MDI meter cannot indicate the total connected load. However, the total load demanded and availed during the course of actual consumption can be detected by the meter. That is my specification. Total load demanded and availed during the course of actual consumption can be detected.
So actual load can be found out, which was used
Total load demanded and availed during that consumption period can be found out.
to avail.
Yes.
So avail, then it will find out what
Yes.
will be. So here he says that it has been found out as 334.
Yes. Now, the inspection report perhaps would be critical, Your Lordship,
Hmm.
because a load survey was done during the inspection report.
Now in the inspection report,
Yes.
they don't mention anything about that MDA.
But the remarks say, Your Lordship,
But this was the bill for that period.
this was the bill for that period.
Then where if it is the bill for the period, why is this the discrepancy?
That aspect, Your Lordship, I'll perhaps have to seek instruction why discrepancy. But the inspection report would perhaps make it clear, Your Lordship, that as per it says that as a part of routine inspection, the metering installation of the consumer is checked in presence of all consumer representatives and officials. Instantaneous readings as noted, seals are found intact, MRI date downloaded, load survey was done, and actual connected load of the factory is found to be 679 kilowatt against the authorized load of 500 kilowatt. This was after a load survey done in the presence.
I understand what is connected load. One is connected load, one is used load.
Yes.
You are going to, can you impose or have unauthorized supply of electricity if it is on the basis of just the connected load or on the basis of use
On
or
the basis
more
of,
than the connected?
on the basis of use, Your Lord.
And
the
if it
basis of
is
use.
used, and if you have not looked into that, just on the basis that there is a connected load, can you impose that?
What the
Because this is a very important aspect. If I'm not, see, you have sanctioned a particular load claim, which is 500. If we see the definition out here in this book, what is connected load? Connected load is the load on the basis of the appliances being fitted to the line of the distributor.
Gotcha.
You see the definition here, connected load.
Gotcha. Yes, Your Lord.
Expressed in kW means aggregate of the manufacturer's rated capacities of all energy consuming devices or apparatus connected with the distributor licensed server line in the consumer's premises, which can be simultaneously used and shall be determined as per the procedure laid down in this code.
Yes, Your Lord.
So this is the connected load.
Yes, Your Lord.
Connected load therefore would mean out here, as I was saying, that these are the connected loads of which one light may not be operating, but that light would also be inclusive of the connected load.
Yes, Your Lord. But the supply code says that even increase in the connected load beyond the sanctioned load is also unauthorized usability.
Where is that?
That is at page number 86 of the, it is clause 7.4 of the supply code.
Increase in connected or connect in excess of the sanction load as per the agreement. Yeah. So this will be one.
Yes.
So you say that if it is, you connect more than what is there.
That is also unauthorized usability. And he has admitted before the appellate authority that he had indeed connected it, but has not used it. But the
Now,
supply code,
his submission is also there.
yes,
But he says that it is only on the basis of the use which can be done, not on the basis. But what do you say about this, whether this regulation would apply in your case?
Definitely I apply, my lord. definitely apply. my
Then
lord.
how do you take care of this one?
Uh,
7.4
F1.
F1.
F1. My lord, in this regard, I want to submit, my lord. I have mentioned about my new machineries, my lord, for what I have applied for, my lord. Because of application and under the process of installation, I have tested only, my lord, connected because of that, my lord. Otherwise, my lord, till that I was not released.
Using it.
Edition. Yes,
That is not concerned.
yes,
I'm
my
not concerned with that. But I'm only concerned as per this. What do you have to say? That if there's an increase in the connected or contracted load in excess of the sanction load,
my lord.
then
that
what
is-
do you do?
That
That
is there,
is
my lord. In
unauthorized.
this regard, I want to submit, my lord.
Because otherwise, the meaning, if this clause was not there, the meaning of the contracted load or the sanction load becomes authorized.
Yes.
And you also applying. Because if I hold it, then look here, whatever may be, it is only on the basis of the X use and shown in the MDI meter or whatever meter, it will be done. And not on the basis of how much I use it. I may not use. Today, I may have 7 ACs out here, but my total consumption is, my total connected load is 20 kilometers, of which I have 10 ACs, of which one will be 2.5, which will be, so it will be 25.
Yes.
So if it is 25, apart from the others, so it is obviously more than that. But wouldn't that come within the ambit of an unauthorized use?
Yes, my lord. In this case, I want to submit, my lord, the paragraph 57 of sitaram S3 rice mill case, my lord. Subpara 2, my lord. Here,
But one thing, in that judgment, whether there was a similar provision which was taken into consideration by the Supreme Court while determining that this is an authorized use, then unless you challenge this regulation that it couldn't have been, you can't.
in other hand, my lord, I want another submission, my lord. I want to submit another way, my lord. That is, this provision may be contradict to the provision 7.4.2 Roman 3 clause B, my lord.
4.2
7.4.3
Roman 3
E.
B.
E.
This is resale.
E, my lord.
In case the meter is working so that the licensee shall make an assessment at the rate equal to twice the applicable
No, my
tariff for the entire consumption,
Uh,
energy, if any, for the displaced period will be deducted. In
But,
case of a
my lord,
meter
I am
is
sorry,
found
my
to
lord.
be incorrect, it's not-
B under A.
Huh?
B under A.
B under
Small
A.
b. Yes, sir.
Yes,
small
that
b.
is what.
My friend is
Small
perhaps
b.
reading from 7.4.2
Roman
Four.
3
Roman 3.
A. Small b.
The heading is methodology for assessment of demand charge and energy charge. And
You are
Sub-
referring to which page?
page number 88.
Yes.
B, your lordship. Subclause B.
Assessment in case of unauthorized use of electricity, change of
In case of connections with MDI meter. The heading is
MDME.
yes, but that your lordship will kindly notice the small star at the top of the page. Methodology for assessment of demand charge and energy charge. There is a star at the top of the page. This entire clause, your lordship,
Yes, my lord. It
only came
force
into
in
effect from 11 January
January
2019.
19.
After
But, my
these
lord,
proceedings were over.
Although it circulated as notification in the month of January, my lord, the law making authority, that is the regulation making authority, has interpreted that in case of AC consumers, it's not applied, my lord. My lord, in an application made by Synpex Company Limited, my lord, the Assam Regulatory Commission has interpreted, my lord, that it not necessarily to assess, my lord, who have equipped with MDI meter, my lord.
For the earlier period also.
Yes, my lord.
Where is
My
it?
lord, my lord. My lord, I like to draw attention to paragraph 9, my lord. Okay, on any type of provisions of the regulation, the commission observes the following: the fixed charges component of the tariff is to be recovered from the consumer on the basis of contract demand of the consumer. The consumer has the option to declare their contract demand as per their requirement, which is independent of the connected load. In case of non-declaration, the contract load shall be treated as the contract demand. Where in case of consumer equipped with MD meter, the licensee shall compare the MD reading with the contract demand, and if load exceeds the contracted demand, then the penalty at 3 times the normal tariff shall be levied as per provision of Schedule of Tariff.
But how did they do it
Yes, my lord.
in 2018 when this particular provision was not there?
Yes, my lord. Because of the confusion made by the official authority, the amendment has inserted, my lord. My lord, the clause.
No. This, if this be
Yes.
methodology for assessment of demand charge and energy charge came into being from 11th of January 2019. How did the authority say that when in a case of consumer equipped with MD meter, the licensee shall compare the MD reading with the contract demand, and if load exceeds the contract demand, then penalty at 3 times the normal tariff shall be levied as per the provisions of the schedule of the tariff.
Yes.
How will they know in 2018 about this 2019 thing?
My lord, the authority has explained, my lord, in earlier paragraph, my lord, relying on the basis of the existing provisions of the regulation, my lord, that is 2.2.3, my lord. Here, my lord, I am reading from paragraph 3 onwards, my lord, paragraph 2 onwards, my lord.
2.2.3.
The authority has explained how they interpret.
Contracted load, contracted load. And
Regulation 2.2.3.
Huh?
Regulation 2.2.3.
Ah.
Roman 2, my lord. Here it stated that contract demand of a consumer shall be LT consumers with MD. The contract demand shall be as per the agreement entered into between the consumer and the licensee, and having regard to the
how did they know that there is a penalty of 3 times to be imposed?
my lord, that is discussed here, my lord.
No, where is the regulation of 2017? Yeah,
This,
that is 2019
This
with amendment.
yes, I have the original copy.
Yes, where is that?
I have one.
Because here they are referring to 2017.
Yes, this is the unamended version.
How did they say exactly the same which is there?
Because I think what my learned friend is trying to refer to, your lordship, is after this order was passed by the AARC, because AARC is the regulation making authority, your lordship, they perhaps thought it fit and proper that after, since this issue has arisen, we are going to amend the regulations. So the regulations were finally amended in 2019. Eight and 2000.
And in that case, why did you refer to the old 2004? Because the inspection was done in 2016
Yes.
and this regulation came in 2017. But how do you make the provisional assessment then? You have to do the provisional assessment as per this then.
Lordship,
Wouldn't
because
this come under, can come into immediate effect? This code shall be applicable to a year.
this came into
Come
effect in
immediately.
this came into effect in 2017, Your Lordship.
Understood,
And
but,
there
but you have not done the provisional assessment then.
The inspection, because my argument would be, Your Lordship, in that case, would be, since the genesis of the proceedings is the first inspection of 7/6/2016. So on that day, the laws as they stood would perhaps be frozen, Your Lordship.
Is it safe? Save as otherwise provided in this code, the ARC code regulation along with other notified by the commission stands repealed. Now, anything done or action taken or purported to have been taken or proceedings initiated under the ARC shall be deemed to have been taken under this code to the extent that the same were not inconsistent. Then how do you bring that? It will be under this one.
Perhaps, Your Lordship, it would,
You see, what is there? Can you see this?
Lordship is reading from the repeal clause.
10.1.2.
Lordship.
Save as otherwise provided in this code, the AREC regulation along with all amendments to date notified by the commission stands repealed.
Lordship.
So it is no longer there.
Lordship.
Notwithstanding anything such repeal, anything done
Lordship.
or action taken.
Lordship.
So in action taken is inspection, but
Lordship.
inspection is not done under this provision. It is done under the provision of
Pretty old, actually.
no under
Under
the
old
act.
regulation.
Inspection is done under the act.
The regulations also are the inspection.
Regulation is there,
inspection
but
is
it is
under the
done.
act.
The power is there under the act.
Power is under the act.
Or proceedings initiated. There's no
Lordship.
proceedings initiated till then. Because the proceedings, thereupon you have seized. And there was nothing done. The proceedings initiates when your suspect becomes finalized on the getting the red and blue.
Because the section 126 starts if on the inspection of any premises.
Understood.
So on the date, perhaps on the date the inspection takes place, then
So
that would be the proceedings date of initiation.
anyways, then also initiated under the repeal day shall be deemed to have been taken under this code to the extent the same are not
Inconsistent.
The commission may at any time such terms as they amend, alter. So it has to be under this one. It can't be under that one in that case.
To the extent they are not inconsistent.
So it will be under this because that has already been repealed and it is not saved. That portion is not saved.
Yes, that perhaps.
So it is not saved. So it will be under this one. Now coming, that is one aspect. But here is the case. But I don't understand how the authorities exactly came to 3 times the penalty, which is exactly the same which was there in 2019.
Yes. Perhaps this issue that the present petitioner is facing, perhaps other consumers might have been raising it before the commission, the Assam Electricity Regulatory Commission. Now the commission being the regulation making authority, perhaps they said that this is how it is to be interpreted. Now even if they state
Now,
that,
how will they interpret something which is not there?
so they had, that is why precisely this order was passed on 8/10/2018.
So that is prior to this, this one coming in.
To make this order effective, Your Lordship,
They
have
made
amended
this.
the regulations in 2019.
So they have given the benefit of that to those consumers.
Your Lordship, perhaps though they have clarified, perhaps the power to clarify is not with the commission unless it is done in accordance with the procedure under 181 and 182 of the Electricity Act.
Understood. But here, whatever they have done
Lordship.
out here,
Lordship.
they have done this, given this type of benefit to others.
No, Your Lordship, the commission has refused to interfere with the assessment.
See, on a reading of the regulations, the commission observed the following.
Yes, Your Lordship.
Can you come to 9?
Yes, Your Lordship.
Where in case of a consumer equipped with MD meter, the license is there. Compare the MD meter with the contract demand. And if the load exceeds the contract demand, then the penalty at 3 times the normal tariff shall be levied as per the provisions of the schedule of tariff.
Lordship.
Which is now out here that if it exceeds as per 7.4.3,
Lordship. 7.4.2.
in case of connections equipped with MDI meter, no assessment shall be made for unauthorized extension over and above the connected load as per the agreement. Penalty for royal in excess of the contract demand
Lordship.
shall be levied at 3 times the normal traffic for the portion of demand exceeding the contract demand.
Right.
So this has to be led with that it has to, although it doesn't mention about the MD meter really. But it is what they wanted.
They wanted it. So to bring their order into force, they have now they have amended the rule, regulations.
But these rules does not say anything to the but the reference being made to the MD meter means it is the trivectorial meter, and as such it will record once the peak.
Yes, if the MDI meter and Trivector meter is
That is why the MDI meter is mentioned. So therefore, you don't need to make an assessment. You will impose the penalty automatically.
Yes.
If you just find it is 697 in your area, so this 197 into 3 times into the normal traffic shall be done. So this is why it has been meant. And
2019
if we
onwards.
read both these two together.
2019 onwards, this will be the position of.
But Mr. Counsel, how can I take these aspects of the matter in this petition when you have not raised in your appeal?
My lord,
Because this court is not sitting as a having a co-concurrent jurisdiction.
my lord, actually, I am submitting my objection as an appeal before the area manager, where I have stated that these machineries have not been in use, my lord. To substantiate
That
that,
is a
my lord,
different thing. I'm not on that. Use or no use has no meaning because it will otherwise come under the meaning of the unauthorized demand. But if you say that in view of this MD meter, obviously that regulation does not come in, but in view of this, you want to take the benefit, why haven't you approached the authority there, the appellate authority?
my lord, to justify that ground, my lord, I have take this legal.
Why should this court look into this when this court is exercising the tertiary jurisdiction?
Yes, my lord, but it is directly, my lord, a legal issue, my lord.
Certiorari prayer is not there. Certiorari prayer is not there.
No, anyways, this court has to set aside that appellate order. So wouldn't that be under what provision? What writ will be issued? The writ will be issued will be a tertiary jurisdiction. Now, if this court is exercising a tertiary jurisdiction, if you have not brought those aspects before the tribunal, why should this court, sitting in tertiary jurisdiction, look into those aspects of the matter?
Yes, my lord. In this regard, my lord, as this ground is a legal ground, my lord.
There's no legal ground out there. These are absolute question of facts as to whether there is an MDI meter or not. How do I know?
My lord,
This is for the first time you are bringing it before this court. How do I know? Do you want me to go there and check it out?
In fact, it was not even taken in the writ petition, your lord.
my lord, in fact, my lord, the APDCL authority has not even followed this regulation in toto, my lord, because they are exercising the process under the earlier regulation, my lord, which was not in existence at the time of inspection, my lord.
Mr. Pathak, any review lies out there?
Your lordship, I have seen, though the power of review has not been explicitly granted,
Then
there have
this
been
court can't
occasions,
judge.
your lordship, where some petitioners have filed review applications before the
Review is
appellate
there,
authority.
but no, this court can't set aside this order.
Because at that point of time, this was a good order, your lordship, as per the law info.
What is wrong? This AREC, this court can't bind this thing because he is passing in just an order, but the order doesn't have the same weight which is there in the regulation.
Yes, my lord, that is not binding, but my lord, the object of the regulation comes from their interpretation, my lord. That's why I'm relying on this, my lord, because they
These
have-
regulations are made under what provision?
181, section 181 of the Electricity Act.
Power of the state commissions to make regulations. So this is made under the regulation. Now these regulations, can these regulations be nullified by the AREC, the commission? No. And how is the regulations made? rules and regulations to be laid before the state legislature. Every rule made by the state and every rule made the state commission has to be laid as soon as after and it is made before each house of the area where it consists of two or when they say on one house before the one house. So this is a thing which is required to be done. So can the AREC, the commission on its own tomorrow say that no, we are not going to follow, we come up with our own.
Can't that way.
Then if they can't do it, then the assessment which has been made has been done rightly. Because at that point of time, it was not there.
My lord, the commission, my lord, regulatory commission, my lord, they have interpreted, not my lord,
There's no
like
question
that
there.
interpretation.
When there is nothing, how can they interpret? When that regulation, earlier regulation is very clear as to how it will be done. It categorically mentions the manner in which it is to be done, in which they had also done it on that particular, and that too, I have recorded that aspect in the order. Yesterday, day before yesterday's order, where they had then A denotes, but they did not mention about a number of months.
My lord,
E,
on that basis of analogy, my lord,
so they have duly done it as per this, as per they have done it as per 7.2, 4.2, Roman 3.1. They've done it. What is wrong?
my lord, one is not applicable to me, my lord, to maybe.
Huh?
My
One will be applicable then.
Yes.
Then one is applicable.
Then
Now
one is
that one is another.
Then-
So matter ends out there. Finished. Enough.
My lord,
You don't have a
already,
case.
already others, my lord, has got relief on this provision, my lord. The appellate authority has.
You
already-
may have a case for the remaining periods. You come up after 2019, I will give you some benefit, but not.
My lord, may I pray for granting a liberty to approach the appellate authority by filing a review, my lord?
You file it. That is your.
My lord, there is directly no such provision.
perhaps
That's
that-
why, my lord.
No, because you see, there are two things. I therefore thought about it. If I, for the purpose of this court directing the authority to reconsider, I have to set aside this, which I am not, because of the fact that it has been done rightly. Now, if you want the liberty and move and file a review, that is your lookout. Absolutely at your peril. But the other thing is, this court can't create an avenue which is not otherwise permitted under law.
127 says that any order passed shall be final. That is the language used in the section.
That's why I approached this when I could my lord.
You can very well take note of those judgments, what do you call that? SBP, Patel Engineering and all. Wherein although section 11.7 says that the order of the Chief Justice is final, then also the Supreme Court says that it can be still reviewed. So you can take that. But I think the best option is either I dismiss it. You want a dismissal, which is going to happen now in 10 minutes, finished. First part of the judgment is already recorded. The second is, want to withdraw, file a review, your peril, you can do. That's your lookout. Or do you want to end the matter here and give some solace to your clients that you don't spend any further money on your client on this litigation?
My lord, after consuming such a long period, my lord, I want to pray one thing, my lord. Give me some time, my lord. I have seen somewhere
No more time.
about three times of penalty, my lord. I have seen somewhere, my lord, but right now I couldn't find, my lord. That's
What?
why, my lord. I have seen somewhere, my lord.
No, there's nothing. The regulation is clear out here, which I could see. Therefore, I was asking him a specific question. Why did they interpret 3 times?
Yes, my lord, that 3 times I have seen somewhere, my lord, in this regulation, my lord. But right now I couldn't find, my lord.
Chalo, I give you one more opportunity. Tomorrow, 2 o'clock.
Oblige, your lord.
But no further, huh? Able to variety vote.
Oblige, your lord.
I'm still holding to your book.
Yes.
Ekon variety. Change हुई थे के लिए who remains here continuous? You? আপনি সদায় থাকেন এইখন থাকিব আকৌ মই বেলেগ এজন বিচাৰিলে আপুনি tomorrow at 2. I'm delivering the judgment tomorrow at 2, but the fact is no further. You just take your instructions that would you like to withdraw or find out whether they permit with a review.
Supplementary item 36, part R.
Hmm.
My lord, on the last session, my lord was
Yes.
pleased to give us an opportunity to look into the aspect of the show cause
You got
notice.
that judgment?
Yes, my lord. I have 3 judgments,
Don't require one.
my lord, of my lord of different years, which has taken care of the point which my lord have. My lord, since 1973, Supreme Court has been consistent in maintaining the aspect relating to how the show cause notices could be. In the year 1973, my lord, the judgment that I'm relying upon is 1973 SCC Supreme Court 149. Kindly, my lord, may allow me to take to the relevant paragraph, my lord.
Where's the paragraph?
Yes,
17.
my lord, paragraph number 9 first, my lord. May I read that? 9. The only ground on which the government proposed to censure the appellant is the fact that the appellant's explanation dated 18 December 1956 in reply to the statement of charges and allegations had been found unsatisfactory by the government. By the expression charges and allegations in this show cause notice, reference obviously is to the letter of October 22, 1956. That letter, it will be remembered, contains 2 charges, namely charge 1A and charge 1B. Appellant's explanation of December 18, 1956, which is said to have been found unsatisfactory by the government, was a reply not only to the charge number 1A, but also to the charge number 1B. Of these 2 charges, so far as charge number 1A is concerned, appellant had been completely exonerated in October 1958. There is nothing, however, in the show cause notice of the October 26, 1966 to indicate clearly that the dissatisfaction of the government with the appellant's reply of December 1956 had nothing to do with charge number 1A. The show cause notice merely states in vague, general terms that the appellant's reply to the charges and allegations was unsatisfactory. Even if we were to assume, there is no reasonable ground for this assumption that the government did not have in mind the contents of charge 1A while serving this show cause notice. There is nothing in the show cause notice to give any indication that the particular allegations regarding which the appellant had failed to furnish a satisfactory explanation were referable to charge 1B. The notice is vague on other grounds as well. As one reads the first paragraph of the notice, the question that at once assail one's mind are many. In what way was the explanation of the appellant unsatisfactory? Which part of the appellant's explanation was so unsatisfactory? On what materials did the government think that the appellant's explanation was unsatisfactory? It is, to our mind, essential for a show cause notice to indicate the precise scope of the notice, my lord, and also to indicate the point on which the officer concerned is expected to give a reply. We have no manner of doubt that the show cause notice in the instant case did not give the appellant any real opportunity to defend himself against the complaint that his previous explanation of December 1956 was unsatisfactory. The appellant did not therefore get a chance at all to show that he did not deserve a censure upon his conduct. Now, in respect of paragraph number 10 also, my lord, little relevant, I'll just read this paragraph number 10. We were told that since the appellant was aware of the charge and also aware of the reply he had given to the charges made against him, it was enough for the government to tell him that his answer was unsatisfactory. It was argued that since the government, since the show cause notice really pointed this out and mentioned that the very lenient sentence of censure upon the appellant's conduct was going to be imposed, there was nothing further that the government could be expected to do in this case. We have no hesitation in rejecting this contention made out on behalf of the state. It is manifestly clear that the show cause notice was too vague to permit the appellant to deal with it effectively, and that consequently the order of censure passed on him is bad and is liable to be struck down. Then, my lord, may kindly come in the year 1991.
What does 17 say? Besides the real issue, when order affects temporary with an objective consideration, assessment of all relevant facts and circumstances, and after giving the person full opportunity to make out his own case in order to consider that seriously
without real opportunity to make an effective representation.
Yes.
May I take my lord to the year 1991 SCC, my lord AIR, Supreme Court 271. It is just one page judgment, my lord. I'll just read the first, my lord, paragraph. The High Court quashed the order dated 39/1988 made by the Board of Technical Education, cancelling the results of the examination taken by certain students who are respondents in these cases. The High Court found that the orders impugned before it were unsustainable for the reasons that the students had not been given proper notices. The notices served on them were found by the High Court to be so vague that they could not have effectively defend themselves in the inquiry. In the absence of proper notices, the inquiry which was held was found by the High Court to be invalid for the violations of the rules of natural justice. Accordingly, the High Court directed the appellant would declare the results and so on. An emphasis is on that proceeding cannot take place without giving a proper cause. Then, my lord, may kindly come to 2007, 5 SCC 388.
Yes.
Here, my lord, may I take my lord to paragraph number 13, my lord. We find that in the show cause notices, there was nothing specific as to the role of the respondent, if any. The arrangements as alleged have not been shown to be within the knowledge or at the behest or with the connivance of the respondent. Independent arrangements were entered into by the respondent with the franchisee holder.
Mr. Burangway, what power does this authority exercise?
My lord,
It can't be an administrative power. The power what the authority exercises is a quasi judicial.
Partly they exercise this power on the delinquent as a quasi judicial body, my lord. When they deal in a situation like the case of the petitioner.
Where they is asking you to show cause.
Show cause, correct.
It can't be an administrative power.
It cannot be, because they will have to deal with evidence.
So if it is a quasi judicial power, wouldn't they have to record reasons?
Yes,
and would it also require taking into account that prejudice is being caused? That you have to know? It can't be kept in the file?
No.
What do you say, Mr. Talukdar? Because what is happening, he doesn't know. He only comes out. Why that order is not to be, when he has been given an opportunity, when the act or the order says that he has to be given an opportunity, you cancel, okay, you can cancel, but suspension not required. You want to cancel, you have to give him an opportunity of being heard.
Right.
A reasonable. If it is to be a reasonable opportunity,
Then yes,
doesn't he have a right to know?
Yes. Yes.
Isn't that the fairness demands?
Right.
And if the what has been let him, what he has only been come to learn, that he has been
Some
rejected.
charges, but he doesn't know what are the charges. But
Wouldn't those
order-
checks be relevant? Because then all the, unless you see, yes, it is good for a lawyer that every time they do, you have a case to file in the court. Very nice. But the fact that these are some basic things which the authority
They
needs
ought
to
to
do.
have known. They ought to have
And
known
if
that.
these authorities does this, they may, or even the court, while dealing with the matter, can know, yes, this is the reason why we have done that. And if he is, you see, when a person is being affected civilly, or civil consequences ensure, not only he has the right to be heard, he has also a right to know what is the result after being heard. Wouldn't it? Then only I think something better will happen in the world. Yes, madam, what do you have to say? Huh? And then only they will know. Now, because the right to be heard also includes the right to know what happened after being heard.
Yes.
To be natural justice. Chalo, let me dictate in your presence. The instant writ petition has been filed challenging the order dated 12/5/2023 passed by the Deputy Director, Food and Civil Supplies and Consumer Affairs, Dorong Mold, whereby the license of the petitioner issued under the Assam Public Distribution of Articles Order 1982 was cancelled on the ground that the petitioner had violated the terms and conditions stipulated in clause 3A, small a to small a bracket, Roman 1 bracket, Roman 2 bracket, Roman 3 bracket, Roman 4 bracket, and clause 3B of the Assam Public Distribution of Articles Order 1982 and the various provisions of clauses 10, 14, and 25 of the same order. The facts leading to the filing of the instant writ petition, as could be discerned from the perusal of the writ petition and its enclosures, is that the petitioner herein was having a fair price retail shop under the Dohi Gaon Panchayat Samavai Samiti at Dorong, bearing license number DMS.2/2022 PDS/Dohi/2010. When did you obtain the license?
I have obtained after the demise of my father. Originally, it was run by my father. After his demise, it was given to me, my lord. By the
When?
Yes, my lord. It was given to me in November 2023. No, it is
We are
pertinent-
November 2023.
it is pertinent to mention here in the petition obtained the license only in the month of November 2023 at page number 7, paragraph number 1, my lord.
Understood. We are in November 2023, and how did you write it when you filed the writ petition
No,
in July?
No, it is-
Fine.
Sorry, my lord. In 2022, my lord, it should be. Not
Eh?
22, my lord.
In November 2022,
An annexure 1 is the copy of the letter, my lord.
after the death of his father, who was earlier issued the license for the fair price shop. It's seen from the records. It's seen from a perusal of the petition that the petitioner, after obtaining the said license in the month of November 2022, claims to have been regularly dispensing the allotted quota of rice to its 471 ration card holders. Good stop. However, in the month of April 2023, during its distribution, the petitioner found out that some portion of the rice for the month of April 2023 was found damaged and not fit for domestic use. This aspect of the matter was informed by the petitioner to its superior authority, that is the Secretary, Dohi GPS, and wanted that the said undistributed rice be taken back and rice fit for domestic use is allotted to the petitioner. However, the Secretary, Dahi GPS, refused to accept the same. It is also for the case of the petitioner that during this period, the petitioner fell ill due to post-operative URSL lithotripsy, lithotripsy, and was having catheter inserted for urine extraction. The materials on record, more particularly Annexure 2, reveals that the petitioner, for his purpose of getting better treatment, was admitted at Sanjeevani Hospital, Guwahati, on 24/4/2023, and thereupon he was discharged on 25/4/2023. Subsequent thereto, on next plan, on 22/5/2023, the Inspector of Food, Civil Supplies and Consumer Affairs, Dorong, along with few other people, visited the petitioner for inspection of his shop and asked for his stock and sale register, etc., and thereafter seized all the register books, documents, articles from his shop and took his signature on blank papers. And after a few days, an order dated 12/5/2023 was served upon him, which was passed by the Deputy Commissioner, now referred as the District Commissioner, Dorong, Mongoldoi, whereby the license of the petitioner was suspended for purported violation of Section 3A, Roman 1, Roman 2, Roman 3, Roman 4, and Section 3B and 3 in Clause 3A, and Clause 3B of the terms and conditions of the license issued under the Assam Public Distribution of Articles Order 1982, for short, the Order of 1982, and various provisions of clauses 10, 14, and 25 of the said Order of 1982. It was further mentioned in the said order of 12/5/2023 that the said suspension of the license was as per clause 15(1) of the order of 1982, and the shall be pending, shall be kept pending and have been issued pending drawal of cancellation proceedings. It is further seen that the population of his shop were thereupon tagged with the nearby FP shop dealer Sri Kulon Kolita of village Borsatra to avoid dislocation of periodically allotted notified articles. You filed a writ petition.
My lord.
You filed a writ petition thereafter.
No, I have filed after find out my cancel.
No, here you see paragraph 5. Therefore, the petitioner had filed the instant writ petition being aggrieved by the illegal or arbitrary perverse action
Of which, my lord,
for suspension.
for suspension I didn't file, so it includes in the current petition, my lord,
Okay.
because the suspension order is also under target.
Pursuant to the order of suspension dated 2/5/2023, on 22/6/2023, the petitioner was served a show cause notice issued by the Deputy Director, Food and Civil Supplies and Consumer Affairs, Dorong Mongoldoi. A copy of the inspector's report dated 3/5/2023, stating therein the violation, stating therein report, where stating therein report
Page 25, my lord.
area was served upon the area. Along with the said show cause notice, the copy of the inspector's report dated 3/5/2023 have also been enclosed. Taking into account the relevance, the said show cause notice is quoted hereunder, is reproduced hereunder, Annexure 4 on page 25 of the quote query. It is the above quoted show cause notice reveals that the authority informed the petitioner that upon perusal of the report submitted by the Inspector, Food and Civil Supplies, Consumer Affairs, Mongoldoi, 2 specific charges were leveled against the petitioner's retail outlet. They were, number 1, not issuing legitimate quota of rice for the month of April 2023. And number 2, not maintaining books of account like stock register, sale register, etc. Further to that, in the said show cause notice, it was mentioned that it appeared from the said report that the petitioner had violated the terms and conditions of Clause 3A, Roman 1, Roman 2, Roman 3, Roman 4, and Clause 3B of the Order of 1982, and various provisions of clauses 10, 14, 25 under the same order. The petitioner was therefore asked to show cause as to why the petitioner's dealing license issued under the Order of 1982 should not be suspended for the above mentioned violation. The petitioner was therefore asked to furnish the reply within 7 days from the date of receipt of the notice. The petitioner thereupon submitted his reply on 3/5/2023, stating inter alia
On 27/6/2023, I have submitted my reply.
27.
Yes, 27/06/2023.
Submitted his reply on
27/06.
27/06/2023, stating inter alia that he had received full quota of rice in the month of April 2023 against 471 cardholders. Thereupon, he started distributing the rice against the cardholders sincerely. It was also mentioned that during the period of distribution of rice, a portion of the allotted rice for the month of April 2023 was found damaged and not fit for domestic use. Under such circumstances, the petitioner decided to return back the undistributed rice to his superior authority. But in due time, he fell ill and immediately proceeded to the doctor for medical advice. Thereupon, the petitioner was admitted at Sanjeevani Hospital on 24/4/2023 for critical operation, and thereupon on 25/4/2023, he was discharged. On his return, he could find that the unused and undistributed rice were still lying in his campus. It was also mentioned that during that period, there was heavy and continuous rain which damaged the rice completely. He further stated that he had not misappropriated a single portion of the rice, and it was on account of his illness and unexpected weather for which he had failed to return back the unused and undistributed rice to the administration. He further stated that he has been maintaining all register books since up to March 2023. And during the month of April 2023, as he was not physically well,
But in today's period, there is a mechanism they can punch and they can release the rice to the consumer.
he was not physically well. He used the punching machine, but as his not well, he used the punching machine to maintain the register book. The punching machine. He further stated that he did not maintain the register book, but he had distributed the rice, and the shortage was only the damaged rice. The petitioner thereupon requested that his license should not be suspended and given a chance to survive his family. Subsequent thereto, on 19/8/2023, the Deputy Director, Food and Civil Supplies and Consumer Affairs Department, Dorong, informed the petitioner and issued the impugn order, stating inter alia that as per the approval of the District Commissioner Dorong and on recommendation of the Area Officer 1, the said authority had cancelled the retail license of the petitioner for violation of the terms and conditions, clause 3A, Roman 1, 2, 3, 4, and 3B of the Order of 1982, and various provisions of clause 10, 14, and 25 under the same order. It is under such circumstances the instant writ petition was filed. The record reveals that by an order dated 27/9/2023, this court issued notice making it returnable on 11/10/2023. And it was further observed that an endeavor shall be made to dispose of the writ petition at the admission stage. On 11/10/2023, when the matter was listed, the respondent authorities did not produce any instructions. On the very day, the learned counsel appearing on behalf of the petitioner had apprised this court that pursuant to the cancellation of the license, there was a move to allot a fresh license in the same area. It is under such circumstances that this court observed that till the next date of listing, the respondent authorities shall not issue any new license in the area of operation of the petitioner. Thereupon, the matter has been listed and has been heard by this court. Give it a 2 remaining. Remember?
24 to 31.
What is the matter about?
Lordship, it's unauthorized construction within ecosystem before building.
So one affidavit will do.
Yes, Lord, similar.
What do you want now?
Lordship, article will adjourn it for today, Lordship, and fix another day.
Okay. The joint prayer of the learned counsels for the parties. The matter stands adjourned to be listed again on
Maybe on the first week of January,
Lord.
first week of January. If Lordship, complete the Lord.
Second week.
on 9th of January,
Lord.
2023-24. This court have also taken note of that these are all pending matters of the year 2015, and as such, no further adjournment shall be granted.
Lordship, in the meantime, if they are intending to file a reply, Lordship, they may
It
file.
is there, look out.
Lordship, there is interim order.
I have already mentioned that there is
Yes,
no.
Lord.
Lordship, the interim-
There is an interim order.
Yes.
Till today.
Not till
From
today, it's
2015 it is going on.
continuing. Yes.
it is still
that
today.
is-
It's till today.
Yes,
Not
yes,
till, till today, or
it's till today.
It is in the hearing list. Can't be. Don't reduce your scope of interim. If it is until further orders, and then I will only make it till the next day.
I'm so obliged, Lordship, but it is still there. I'm so obliged.
till the next day.
The interim orders passed earlier shall only continue till the next date.
of that.
My lord, if I may, similar prayer, my lord,
In the orders section, my lord, there are three matters, 11, 12, and 13. My lord, in the orders section regarding three matters, my lord, item number 11, 12, and 13, my lord, where for the writ petition, my lord, the lordship had directed us to file the affidavit. My lord, we have filed the affidavit on the 28th. My lord, the matter has been led by Mr. A. Sattar. However, my lord, due to some medical emergency relating to his wife, he had to leave the court premises.
Item number?
My lord, the orders item, my lord, 11, 12.
Why the matter has come up for orders?
My lord, due to the fact that we had to file an affidavit.
Oh, these matters. I remember that plan.
Yes, my lord. Yes, my lord, regarding that piece of land, my lord.
Then
My
it
lord,
has been clarified by the
matter
deputy
may-
commissioner. Who are you? You are the
my lord,
petitioner.
For the writ petition.
So the petitioner was appeared by Mr. Sattar,
Yes, my
then
lord.
Mr. Samua.
Yes,
So how does Mr. Hassan come into the scene now?
my lord, I simply pray for
Mr. Sattar, his wife is suffering from medical emergency.
What about Mr. Samua?
He is also lordship is some severe dental surgery lordship. That's why he is not coming to the court lordship. Lordship, kindly adjourn this matter for today only.
Who are you?
Lordship, I'm being on behalf of H1. That's why. K. Barbujari, Lordship. We took consent from the correspondent party. Lordship.
But you have been evicted, no? You have been evicted. There is no stay. Who is appearing for revenue? Oh, Mr. Hendrik, you will be there. In that matter, these are matters pertaining to that place. What do you call it? Boragaon.
Lordship.
I remember.
Lordship, kindly adjourn this matter only for today, Lordship.
Not for today. These matters will go. The counsels appearing on behalf of the petitioner seeks for an accommodation on account of the ailments of all the counsels who have addressed before this court on earlier occasions. Taking into account the above, list the matter in the first week of January.
Bless.
In the backdrop of the above, let this court take note of the submissions which have been made by the learned counsels appearing on behalf of the parties. Mr. H. Buragwai, appearing on behalf of the petitioner, drawing the attention to clause 15 of the order of 1982, and more particularly to clause 15.2, submits that no order of cancellation can be made unless the licensee have been given reasonable opportunity of stating his case against the proposed cancellation. He submits that the show cause notice which was issued on 22/5
22/6, my lord.
on 22/6/2023 do not in any manner state that the license would be cancelled, is proposed to be cancelled. He submits the perusal of the said show cause notice would only show that the petitioner was asked to show cause as to why his license should not be suspended. He further draws the attention of this court to the order of suspension, wherein it has been mentioned that the suspension has been made pending drawal of cancellation proceedings. There has been no cancellation proceedings initiated with the show cause, and for which the impugn order so passed without a show cause notice or giving an opportunity to the petitioner to state his case is therefore in violation to clause 14 of the order of 1982. He further submits, now, in addition to the above, he further submits that a perusal of the, even a perusal of the show cause notice would show that there is the said show cause notice is completely vague, as there is no mention on what basis the issuing authority had formed an opinion, had formed any opinion on the basis of the inquiry report dated 3/5/2023 that the petitioner had violated the conditions stipulated therein, the terms and conditions of the order of of the license, as well as the order of 1982. Further to that, the learned counsel submits that when the provision when section 50 clause 15(2) stipulates that there cannot be any cancellation without giving the licensee a reasonable opportunity of hearing, of stating his case. It presupposes that when an order is being passed after a show cause has been filed, the order should contain reasons referring to the impugned order dated so and so. The learned counsel submits that there is no mention whatsoever as to the reasons why which, on the basis of which the authority came to a finding that the petitioner had violated the terms and conditions as alleged in the said order. He therefore submits that the impugned order dated 19/8/2023 therefore is required to be set aside and quashed. Mr. B.J. Talukdar, the learned counsel appearing on senior counsel appearing on behalf of the respondents, submits that you gave us some documents on the last occasion. Na? Kagol ko kuch chilate.
I have given another set.
Submits that the records pertaining to the cancellation of the petitioner's license have not been forwarded to him. What has been forwarded by the district commissioner, Dorong Mongoldoy, is that the petitioner was issued a show cause notice on 22/6/2023 and subsequently on 19/8/2023, the license of the petitioner was cancelled for violation of the terms and conditions of the license and for violation of clause 10, 14, and 15 of the order of 1982. So, the documents which was forwarded to the learned counsel by the district commissioner, Dorong Mongoldoy, was the order of suspension, the show cause notice, the order of suspension dated 12/5/2023, the order, the show cause notice dated 22/6/2023, as well as the impugned order dated 19/8/2023. Yes, what is your submission?
My submission is that 22/6/2023 is in fact the notice under section 15(2). Although it says that the suspension order should not be passed instead of cancellation order. Only that, but in all.
The learned
sections
counsel,
of the-
senior counsel further submits that in the order, in the show cause notice dated 22/6/2023, and submits that the said show cause notice dated 22/6/2023 is a show cause notice coming within the ambit of clause 15(2) of the order of 1982. It was, however, there be that as it may, he submits with all candor that that instead of that, inadvertently in the said show cause notice, it was mentioned that should not be that submitted. It was mentioned as regards why the license should not be suspended, which ought to have been, why the license should not have been cancelled. Anything else?
And another submission is, my lord, that reason that allegation was not given in the show cause notice, but he was served with a copy of the report, so he knew.
He further submitted that although the show cause notice, and he further submitted that the petitioner was well aware of the reasons for which the show cause notice was issued, inasmuch as the inquiry report dated 12/5/2023, 3/5/2023 was furnished along with the said show cause notice. I've heard the learned counsels for the parties and have also perused the materials which have been placed, which are on record. This court finds it relevant to take note of clause 15 of the order of 1982. The said clause 15 is quoted herein under. From a perusal of clause above quoted clause, it reveals that clause 15.1 of the order of 1982 empowers the licensing authority to cancel or suspend by way of an order the license. Clause 2, subclause 2 of clause 15, however, puts a check puts an embargo upon the licensing authority not to cancel the license forthwith, but to give an opportunity of hearing, to give a reasonable opportunity to the licensee of stating his case against the proposed cancellation. It further stipulates that the said proceedings, it further stipulates that the suspension period of the license or the power exercised for suspension of the license cannot exceed a period of 90 days. If there is no opportunity of hearing, opportunity is given to the licensee. This aspect of the matter has vital relevance for the purpose of deciding the instant dispute. In the backdrop of the above, if this court takes note of the facts involved, on 3/5/2023, the inspection was carried out on what is the date of inspection?
On 2/5, my lord.
On 2/5/2023, the inspector, Food and Civil Supplies, and CA is what? Consumer Affairs, Dorong, had carried out an inspection. Thereupon, on 12/5/2023, the license of the petitioner was suspended pending withdrawal of cancellation proceedings. On 22/6/2023, show cause notice was issued stating inter alia, show cause notice was issued stating inter alia as to why the petitioner's license should not be suspended. The petitioner thereupon submitted his reply on 27/6/2023. Thereupon, on 19/8/2023, the impugned order was passed. Therefore, for the period from 12/5/2000, 12/5, na? 12/5. From 12/5/2023 to 19/5/2023, 19/8/2023, the period of 90 days was already over. Be it as it may, taking into account the last part of clause 15(2), it stipulates that ordinarily, if we take into consideration, this court takes note of again clause 15(1) and conjointly reads clause 15(1) with clause 15(2) of the order of 1982. It would show that the licensing authority has a power to suspend the license. However, if it is proposed to suspend the license for a period more than 90 days, an opportunity has to be given to the licensee. It is under such circumstances, it can be presumed, taking into account clause 15, taking into account the said provision, that the said show cause notice in that view of the matter, it is the opinion of this court that the submission of Mr. B.J. Talukdar, the learned counsel, senior counsel appearing on behalf of the respondents, that the show cause notice dated 22/6/2023 was inadvertently mentioned as for suspension and not for cancellation. Would not be tenable in the opinion of this court, inasmuch as if the licensing authority proposes to suspend the licensee, which have in fact been done in the instant case, the license, for a period more than 90 days, there is a scope of issuance of a notice, prior issuance of notice, issuance of an opportunity, giving an opportunity of hearing to the licensee. Therefore, it is the further opinion of this court that the submission made by the learned counsel for the petitioner that the notice which was issued on 22/6/2023 was only a show cause pertaining to suspension and not for cancellation cannot be ruled out. On the same basis, it would be therefore be seen that clause 15(2) of the order of 1982 was therefore not complied with prior to issuance of the impugned order dated 19/8/2023. For which the impugned order dated 19/8/2023 requires to be interfered with. This court further finds it also relevant to take note of that from a perusal of the show cause notice dated 22/6/2023, even considering that there was an inadvertent mistake, would show that the licensing authority who issued the said show cause notice did not apply its mind while before issuance of the show cause notice. Merely, it is the opinion of this court that merely enclosing a report wherein there are certain allegations would not suffice unless and until the licensing authority stipulates the infraction of the order of 1982 as well as the conditions of the license by the licensee. This aspect of the said opinion of this court is based upon the observations of the Supreme Court in the case of Sri B.D. Gupta versus State of Haryana, reported in 1973, 3 SCC 149, wherein the Supreme Court observed that a show cause notice should indicate the precise scope of the notice and also to indicate the points on which the officer concerned is expected to give a reply. This court further is of the opinion that as the inspector, that opinion, that merely on the basis of a report of the inspector, the license cannot be cancelled. The license can only be cancelled by the licensing authority upon application of mind to the report submitted by the inspector, and after giving an opportunity to the licensee to show cause or to state his points, his case pertaining to the infractions pertaining to the violations so alleged in the said show cause notice. It is also on this basis, it is the opinion of this court that the said show cause notice being vague is liable to be interfered with. This court further finds also relevant to take note of that when a provision is given thereby giving an opportunity to state, or for that matter, to show cause, the reasons why the said show cause is not satisfactory is required to be informed to the person to whom it has to be, the reasons for which the such causes shown is not satisfactory has to be mentioned in the order, inasmuch as it is a well-settled principle of law that public orders affecting, what is the term? Public orders?
Affecting public policy.
Public orders?
Publicly made.
Publicly made, having consequences, has to be judged on the basis of the reasons assigned and not subsequently on the reasons given. As held by the Supreme, as was held long back by the Privy Council and by the Supreme Court in the case of Govardhan Das Bhanji versus Police Commissioners, AIR 1952 SC page 60. It is therefore this court is therefore of the opinion that as the order, impugned order, does not in any manner state the reasons as to why the cause so shown was not satisfactory, the said impugned order should also be set aside on that count also. This, be that as it may, accordingly, this court therefore sets aside the order dated 19/8/2023 for the reasons above mentioned. Be it as it may, this court as this court has interfered with the impugned order on the grounds of violation of clause 15, as well as on the ground of failure of natural justice, and have not dealt with the merits, this court grants the opportunity to the respondent, to the licensing authority, to take appropriate steps, grants liberty to the licensing authority to take appropriate steps within 30 days, the appropriate steps as per the provisions of the order of 1982. It is made clear that if the said steps are initiated, the same be completed within a period of 90 days. During this period, although this court had set aside the impugned order dated 19/8/2023, the license of the petitioner and the license of the petitioner stands revived, but the same shall remain in suspension for this period of 90 days from today.
And all other arrangements.
May I make a prayer? Yes. But so far as my suspension goes, because as I have also challenged the the contents of the so-called.
Mr. Buragoy, I have escaped myself in delivering the judgment and did not look into the merits. The merits are very bad for you. You have admitted.
Thank you very much. I'm deeply obliged.
In the interim
And
measures.
the order of interim so far
Because
that they will
they
not
were
issue
attached
any
to
new
some-
It is
license.
also made clear that during this period, it is also made clear that as the license, the learned counsel appearing on behalf of the petitioner submits that the interim order passed by this court is required to be extended till the finalization of the said proceedings, if so initiated. It is the opinion of this court that as the license had been restored the question of issuance of fresh license would not arise, and as such, the interim order need not be extended.
Hereby meaning, my lord, that they will continue with my license. I will continue with my
But
license.
there,
Yeah, of course. And then, my lord,
license will be issued if the license is cancelled. I have restored it.
Yes,
Where is the
so
question?
will not- highly obliged, deeply obliged.
Item number 6, extend.
Yes. What is this? APDCL.
May I please, your lordship?
Yes.
Lordship, may kindly take up the affidavit filed by the respondent number 5.
I've seen it. Who says that it is your fault?
Lordship, may kindly come to page number 5,
Yes.
page number 4, Lord.
Yes.
And before that, Lordship, may I read 2 paragraphs, Lordship?
Hmm.
Page number 2.
Hmm?
Page number 2 of the affidavit.
Hmm.
That
Yes.
the case of the writ petitioner is that the husband of the petitioner, namely so-and-so, died on 13/7/2020 due to electrocution. The petitioner submitted representation on 12/4/2021
Hmm.
before the managing director, so-and-so. The Honorable Court issued notice in the matter on 17/8/2021 and an inquiry being conducted in respect of the electrical accident that leading to the death of the petitioner's husband, namely so-and-so.
Hmm.
Notice was issued, Lordship, on 17/8/2021.
Hmm.
The said report dated 23/12/2021 is presented by the defendant by filing this affidavit.
Hmm.
Now, Lordship, inquiry was conducted, Lordship, on 23/12/2021.
Hmm.
Lordship, may kindly come to the inquiry report.
Hmm.
Page number 4.
Hmm.
Clause number 9. Brief description of the accident.
Hmm.
From the document furnished by the concerned official of APTCL and the facts gathered from nearby residents and circumstantial evidences, the victim with his father went out from home at around 11 a.m. for collecting firewood from Kolong River on 12/7/2020 by rowing a boat. At that time, it was raining and water level of the river was increased due to flood. While the boat of the victim was passing below the bare live 11 kV overhead line, which was drawn across the river, accidentally the victim came in contact with the bare live 11 kV overhead line through the oar and got electric shock, and he was immediately shifted to the hospital and died on 13/7/2021. From the above stated facts and circumstances leading to the incident, it appears that the victim received fatal electric shock by coming in contact with 11 kV overhead bare live conductor through the oar, while the boat of the victim was passing below the bare 11 kV overhead line, which was drawn across the river, caused the accident. Contravention. From the facts and circumstances leading to the accident, it appears that there occurred contravention of regulation 64(2) of so and so regulation on the part of victim. Now, let's kindly see the recommendation first. The provision of the Central Electricity Act, measures relating to safety, regulation 2010, should strictly be complied with by all concerned to prevent such accident in future to ensure public safety. The supplier of the electricity, that is APTCL, should aware the public about the danger of coming in the vicinity of the energized line and installation during flood time, and make this date by de-energizing where the flood water increase substantially, reducing ground clearance to avoid such unfortunate incidents.
Hmm.
May I please this, Lordship? Central Electricity Authority regulation.
Hmm. Then,
Lordship, this is the Central Electricity Authority regulation. Lordship, may kindly come to regulation 12.
yes.
internal page lordship 106, chapter 2, general safety.
12, regulation 12, page.
Page number 106, sir. Chapter 2, chapter 3, regulation 14.
Sorry. Deposit of printed copy.
This is the gazette notification.
Ah.
Printed.
Okay.
Gazette notification.
No, understood. Clause 12 is deposit of printed copy.
Lordship clause 14, Lord.
Oh, 14.
Regulation 14.
Yes.
General safety requirements pertaining to construction, installation, protection, operation, and maintenance of electric supply lines and apparatus. All electric supply lines and apparatus shall be sufficient rating of power, insulation, and estimated fault current and of sufficient mechanical strength for the duty cycle, which they may be required to perform under the environmental condition of installation, and shall be constructed, installed, protected, work. Lordship may kindly come to sub-regulation 4. All electrical equipment shall be installed above the highest flood level. Sub-regulation 4. All electric equipment shall
No, Mr. Counsel, why are you bringing this 2023 regulation? We are concerned with 2010 because this happened then. Incident happened when? 13/7/2021.
21.
And this regulation is of 2023.
May I read that portion, Lordship, from the 2010?
Absolutely. Better. Because that is why I'm saying this reference to 64.2 is not here.
Yes, but it's now 68. In the
Whatever may be,
yes.
but then also it is not here.
But Lordship, so far as the highest flood level is concerned, Lordship, it is specifically mentioned in the new regulation.
No, if it is not there earlier, then why will you there?
Earlier,
You are referring to which one? General clearance.
general clear.
For the purpose of computing the vertical clearance of an overlaid line, the maximum sag of a conductor shall be calculated on the basis of maximum ceiling. Now, one thing, tell me, these reports which are being given by the electrical accident, are they final and conclusive between them?
My humble submission would be, Lordship, as because, Lordship, may I place the regulation, that is Assam Electricity Regulatory Commission, compensation to victims of electrical accident regulation 2019. This is applicable in this case.
Where is that? Yes. Where is it?
Lordship may kindly come to chapter 3, internal page number 1482. That is relating to compensation.
Yes.
And before that, Lordship, may I read one paragraph from the chapter 2? That is the previous page, Lordship, 1481. It is regarding safety standards. I am reading, Lordship, 4, sub-regulation 3. The licensee or generating company, including CPP, shall strictly comply with the safety regulation and norms notified by the Central Electricity Authority or other applicable regulation as notified from time to time, including any amendment. Lordship may kindly come to the chapter 3, that is liability for compensation. Notwithstanding anything contained in any other law in force.
What do you want to say from this?
Lordship, the report, Lordship, which has been submitted by the electrical inspector, that is not the conclusive one, Lordship. Thereafter, as because, Lordship, the electrical inspector here in this case, Lordship, they stated that, Lordship, contravention is there. At the same time, at the recommendation part, Lordship, stated that It was the duty of the APTCL to de-energize the electric line, Lordship, where the flood level was so high.
Where is it mentioned?
Page number 5 of their affidavit, that is the report.
It doesn't say the provisions should strictly be complied with at all concerned to prevent such
Last line.
accident in future to ensure public safety. The supplier of the iman should be aware, should aware the public about the danger of coming in the vicinity of the energized line and installation during flood time and make these dead. No, Mr. Counsel, I understood. Everything is understood. The question therefore is, because I have heard this matter, otherwise I wouldn't have.
Yes.
The question is as to whether it was all these have happened or not. Couldn't that come within the ambit of a civil dispute? You see, if I am to exercise the power, I can only exercise the power as regards 4 lakhs, nothing more than that, plus interest. But that is only subject to clause, regulation 5 stating that the APDCL was at fault. Now, as of now, the electrical accident report, which obviously you say may not be correct, I am also think, yes, because here is a case where the line which should have been 5 meters, if I remember correctly, was running under the water. And as such, 5 meters is 15 feet. It couldn't have been. And if it was running under the water, there should be. But the fact that can these 4 things be decided by this court, unless this, on what basis will this court hold that the fault was there of the APDCL on the basis of this document? Because anything else, this court will be entering into the facts, which this court can't. Understand? That is the only reason why I'm saying. And that was the reason why I fixed it today. Because on that day, it was a Monday or Wednesday, I was not able to give much time for that.
Yes,
If you are agreed, you challenge this. You have a good case because it is a case as to, but I think you will get more compensation if you look into the provisions of this one, section 9, regulation 9, which still provides you all your rights.
That's true, Lordship. But may I submit? Lordship, so far as the procedural part, which has been mentioned at chapter 4, Lordship, of this regulation, Lordship. The procedure says that, Lordship, how to provide the compensation. Lordship, once the report of the electrical inspector is there, thereafter also, Lordship, there should be one decision from the managing director. That's because, Lordship, here in the recommendation part, the electrical inspector was totally silent as to whether I am entitled to for the compensation or not. Lordship, may kindly have a look at regulation 12, Lordship, chapter 4, that is procedural part. The occurrence of the electrical accident leading to loss of human or animal life or injury shall be reported to the electrical inspector by the concerned officer of the licensee operating company under section 161 of the Electricity Act. And with the intimation of accident rules 2004, so as to reach the above authority within 24 hours of the electrical accident. Here, Lordship, in this case, Lordship, no report, even Lordship, that intimation was also not given. We have submitted representation in the month of May, Lordship. Thereafter also, they have not conducted any inquiry as per the section 161. It is only when, Lordship, they received the notice from the Honorable Court, they have conducted the inquiry.
Understood, but the inquiry report may be wrong. Inquiry report may be wrong. But how can this court, they hold them? Yes, you have to pay because they say the inquiry report is in their favor.
Moreover, Lordship, quite may I place one judgment of the Congress on this point.
Yes, what is it?
Here, Lordship, in this case, Lordship, the inquiry report of the electrical inspector was interfered with by the Honorable High Court of Bombay by exercising jurisdiction under Article 226 of the Constitution of India. The Maharashtra State Electricity Distribution Company Limited, through its executive insurance, versus electrical inspector.
So the inquiry report was put to challenge there
Yes, Lordship,
by the electricity department,
by the electricity department.
and that the Bombay High Court has interfered with.
Yes, Lordship.
Have you challenged the electricity report?
Lordship, that occasion was not there, as because, Lordship, they have conducted.
Who has
the
asked you not to file a separate writ petition?
Yes, Lordship. That I will file a separate writ petition. Let the writ petition be kept pending. I will argue both the writ petition today. As because, Lordship, in this case, Lordship, the specific ground was there. The inquiry report was preferred even without hearing the authorities of the electricity department. Here also, Lordship, they have received the notice from the Honorable Court, and thereafter they have conducted the inquiry.
No, but they have heard the APDCL authority. That is
But
what
they
is
have
there
not
in the
heard us.
inquiry report.
They have not heard us, Lord. No notice was issued.
Not to you. They have heard them. They have heard the authorities and also the people nearby.
Lord,
That is the reason why.
I read two paragraphs of that.
First of all, this court, whether this court is bound by the Bombay High Court judgment is different.
Yes.
That is another aspect. But the fact that this judgment will only show that the inquiry report can be interfered under 226. That's all. Nothing more than that. But the fact as to whether there was any violation or there was any rope out there, whether that line was above 15 feet or not, how can this court know? Did you put the oar on with your hand out there on top, or did you was the rope, the wire going under the water? These are all questions of facts. Anyways, one fine day this matter will get disposed of. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 6 weeks.
I level it.
You take these, it will help you.
I level.
Item 32 and 33.
It is infectious, my lord, so your
Your matter is infectious.
33 is in fact same tender process, my lord.
33 is infectious.
Yes.
Which one? 6039.
603. Remaining
What is 6637 is what?
667 is the one. Sir.
What are you challenging?
My lord, your lordship will kindly see, I'm just giving two dates. On the page 21, it was the NIT issued. No, last order, your lordship, I think it should.
So for as to why they impugn
611
conditions
order
basis of the demand shall not be set aside in court.
611/20.
So, conditions. So you are challenging the conditions 4.8 and 1.13.1. Is there a stay?
There is a stay, there, that it says, my lord,
No stay was vacant. Stay was not now. As of now, no stay, Lordship.
Huh?
As of now, there is no.
What has happened to the tender?
Lordship, they have applied for, during this period, we have opened the tender process, but nobody has taken it up, Lordship.
Huh?
Nobody has taken it up. We are about to go for the tender, Lordship.
Retender.
Yes.
611.
Actually, as for the 611 order, Lordship, we have given a, today we have an instruction, Lordship, as per 611 order, Lordship, against the.
Huh?
I have an instruction against the 611 order, Lordship. On instruction.
So what is the clause? 4 point?
My lord, your lordship will find it at page 72.
70?
Of the
Yes.
petition number.
4.8. If a bidder submits tender for different fishery, but only one fishery will be settled considering the interest of the actual fisherman community and also considering the highest bid value of the bidder.
Second is 30.
As per the condition of 2.8, if the highest bidder has withdrawn, as per the condition 2.8, the second hire can be given settlement at the rate offered by the first hire. Otherwise, the corporation will have a right to issue fresh NI.
Government has filed affidavit. Government says rule doesn't say so because they have to follow the spirit of the fishery rule. In the fishery rules, my lord, when there is no such condition. This is the government affidavit, it supports the petition. So, my lord, this petitioner who was settled with one society, my lord, it's a fisherman society. They were settled with one.
But whether the highest bidder will lose his earnest deposit?
Yes, yes.
No,
You will lose.
Just for
per
example,
rule,
A, B, and
as per
C
condition
quotes submits a tender.
Lordship.
A quotes 1 lakh, B quotes 80,000, C quotes 60,000.
Lordship.
Now A, does he have to give an EMD?
Yes, yes.
Yes,
At the time-
if A refuses to take, then his EMD,
EMD is forfeited.
but not the second one. If
No, understood. But the second one would be given at 1 lakh.
yes, if he wishes, Lordship. It is not
Understood? Will be given at 1 lakh.
Lordship.
But he would not lose his
No,
forfeit.
no.
Yes, what is wrong with that clause?
My lord, he is the first bid in all cases, my lord, even under the fishery. If the first bidder loses, my lord, withdraws, second bidder is given.
But why will he be given at the rate which is already fixed? He will go for a fresh tender to get it.
Rate at the, my lord, tender is called, first, second, third bidder is there. First bidder, my lord, may be highest, my lord. If he withdraws, my lord.
And why are
he
you
should-
challenging this clause?
Because, my lord, first is, this is not a reasonable restriction.
No. How?
4.9.
Why are you challenging this clause?
Because, my lord, I am.
You
not
know
allowed
that
to
the first
tender.
bidder will withdraw.
No, I'm not allowed to, submit tender.
Huh?
I'm not allowed to submit tender.
No, but why are you challenging 13.1?
13.1 is also, because, my lord, I am second in all the other, my lord, in previous occasion, in respect of the same bill, my lord, tenders were issued. First, second, third bidders, my lord, they have withdrawn the bill, withdrawn their bids and their securities were forfeited. So I am the next one, my lord. The next one, my lord, I am supposed to be given the bill, my lord.
But why
the
will
first
you
bid.
be given at a lesser price? And how do you know that you will be the third bidder?
My lord, they have withdrawn, my lord. They have withdrawn.
How do we know they will withdraw?
No, they will withdraw. My lord, first NIT was issued on 2/5/22. 2/5/22. Then, my lord, there, my lord, I think first, second, and third higher bidder will be, and the fourth bid. So therefore, I should have been given. Instead of that, my lord, they
But
have
are you
done-
challenging that action?
My lord,
But are you challenging that action? No.
no, thereafter, my lord, they have again issued tenders in respect of the same.
Then
So there also I have challenged, and now the condition has come that if the any tenderer has got a, my lord, fishery, they will not be able to file tender, submit tender. So therefore, this honorable court by an interim order directed, my lord, that the tender should be taken, but no final order should be passed. But for some time, my lord, we could not follow, I think, from the month of, so interim order was not continued. So, but even if, my lord, interim order is not continued, we have submitted our.
so you are more serious on 4.8, not 13.1.
4.8,
13.1, I don't find anything. So that clause goes. But what about 4.8? That
4.8.
you have one tender, you have one fishery, then you are not entitled to bid for the second one.
Second.
Let's
How
read
can you-
4.8. Where is 4.8? As on
And and the full court decision, your lordship will also taken. Restriction has to be placed. This is not a reasonable restriction for all purposes.
So in this tender, there are various fisheries, I suppose,
There is-
of which if you submit for all the fisheries, but you will be only considered for one.
No, my lord, if I am a holder of one fishery.
No, that doesn't say.
It says so, my
See,
lord.
4.8. If a bidder
Submit tenders
society
for-
submits tenders for different fisheries,
But only one fishery. will
but
be settled.
only one fishery will be settled considering the interest of actual and also considering the highest bid
lord,
value.
Lordship is right, but here, my lord, I have been already given settlement of one fishery on 16/7/22. So therefore they are saying you are not eligible to bid.
Then it will be different. But is that the condition? No,
That is-
Mr. Sharma, the condition says that there might be many fisheries which have been put to tender only, and I may apply for all,
Lordship.
but I may be only given one fishery, subject to being the highest bidder.
Oh, no, yes, sir. No, yeah. Maybe that I could audit on yes, sir.
So, if he quotes for 10,
Lordship.
there might be 10 fisheries
Sorry,
which
yeah,
may be
Lordship,
put to sale.
These tender documents is for we used to prepare initially, Lordship. This tender for all the bidders, all the fisheries.
Understood.
Lordship,
So, your case says, as per the tender, how many tender
No,
fisheries have been put to
it's
sale?
applicable for all the 190 fisheries, Lordship.
Huh?
190 fisheries, this tender documents, Lordship. Here we have here the fact is that if he gets another fishery, then we will not settle him. Considering the
No, your case is that if a person bids for maybe 190 fisheries also,
Hmm.
but he will be given only one fishery,
yes, Lord.
subject to being the highest bidder. That's it.
Yes,
That is your,
yes,
that
yes.
is the clause.
Yes, Lord.
Okay.
Yeah, he is already having a fishery, Lord.
Where?
In our case, in our department, Lord.
But this is only subject to this tender. But is it that the condition of the tender that if you have already a fishery, then you would not be? That is not the condition of the tender.
That is not
Then-
that is not clearly written, Lord. That, but we are following this rules. Actually.
You
Yes.
cannot. How can you stop him from bidding that? Because he has another fishery. But if you have 100 fisheries or 150 fisheries which are there put on tender,
Okay.
he quotes, he will be only given one bid. That is the term. How can you stop him from
Yes, Lord.
applying others?
Yes, it was a yes, Lord. But in practical, Lordship, you are using that for procedure that if anybody is having another fishery, you are not
On
giving
what basis?
Lordship.
You don't have the law.
No, serious. It is. Yeah, I have just seen it, gone through it. Audit manager must be it should have been written if he is having another fishery. Yes.
No, this is the term of the tender. And the term of the tender categorically mentioned that if you put for 10 fisheries or 100 fisheries, you'll be given only one. It does not say anything that if you already have another fishery, which is already there under the AFTC or something, then you would not be allowed. That doesn't say.
Yes. But that is in future we'll rectify this clause.
That is your lookout. I am not there.
Lordship, this part is being we have
But the 4.8,
Lord, we interpreted this way,
13.1
Lordship,
is
and we
fair.
have settled it also.
No, 4.8 is also not wrong. It's okay. 4.8 is wrong, but you cannot stop him because he has another fishery with the AFDC.
Lordship, because as per this clause, Lordship, this clause is not.
But now you are withdrawing that. Are you going for a fresh tender?
Yes, Lord.
What do you mean?
Third time this tender has been issued.
No, let them do. They are losing the money.
No, but third time they have issued, we have submitted tender, and your lordship will kindly see the last order which has been passed by.
Now, have they
Honorable
rejected
Justice.
your tender?
They have not opened my tender despite the party.
Have they rejected your tender?
They have not accepted my tender.
No, they have. I think they have participated in the tender, Lordship, in earlier one.
They have not accepted that. there is an interim order passed by this court, but for certain reasons, it did not continue. But they,
No, here you are
we
only
have
asking.
participated. We have participated.
Now, are you going ahead with this retender or not, Mr. Sharma?
Yes, we are going for return.
With
We have
a-
only, we have initiated it actually. Lordship, last day, Lordship, Honorable Court has asked me that question. So we hold it informally, Lordship. Actually, there is no stay. Only because there was a question query from the court that whether this mission.
Are you going ahead with the fresh tender
Yes,
or not?
Lordship. Yes,
Where is your instruction?
yes, my statement can be recorded, Lordship.
My goodness.
Yes, Lordship, I will written.
Tomorrow, Mr. P. Sharma is out of Fishery Department. There is
No, Lordship,
another one
today
coming
today,
in.
Lordship, it is online, Lordship. It can be recorded, Lordship. If the retender is
It
going
is
on.
online means? Who is going
Everyone
to
is
see?
looking.
You cannot record it. You can use it. Have you seen
Instruction, I will take it,
10.2?
Lordship.
Huh?
I will get the instruction if Lord. Written instruction.
Get the instruction tomorrow, 2 o'clock.
Lordship.
Only thing, my lord,
If you are going for a fresh tender
Yes.
on written instruction,
Lordship.
then there is nothing else.
Nothing.
Because he doesn't have a right on the basis of
Lordship,
if
I
you
can
want to
give
go for
even at the last hour also I can give it by giving.
very well, get it.
my lord, 6,
At least something happened.
Lordship.
Huh?
6, 11, 23.
6, 11, 23. 6, 11, 23. Yeah. Starting the mission submits the after the interim was when the film was to went ahead, but all the people using high price have declined to apply as a result of which they are now continuing to go for a fresh tender. However, on the pointed note made by this court as to whether since no other bidder is willing to accept it, the FTC authority would still be open to settling the issue with the head of mutually agreed. So this they have not agreed.
Lordship.
They say that they are not agreeable for that. So that
They are not accepting my tender. The tenders which you have submitted, my lord, there is an interim order to accept my tender, not to take a final decision in the matter. They are disobeying that order. It amounts to, my lord,
for that you file contempt.
Contempt.
We'll see when contempt, but today we finish up these two matters.
Lordship.
So, but they will
Yeah,
be
half an hour time,
If
Lord.
your
On
lordship
written
clarify that, if your lordship clarify that, my lord, although I have a fishery,
I'm not going to say anything. I will say that as they are going for a fresh tender, nothing remains.
But the clause has to be decided, my lord.
Why should I decide the clause of a non-existent tender? For that, Mr. Das, I will consider when a matter is there on that date. When a tender, live tender is there. On an excess non that is a question which will be decided in a proper case, not in this case, Mr. Why should I quote on respect to a tender which they are not going ahead? Why should I decide anything? There are other matters, important matters to be taken.
Regarding the condition.
You challenge it, and if I am hopefully if I am taking bench 4, I'll take it on the motion day and finish it up.
Lordship, after half an hour, Lord.
Yes, get it. Written one.
Lordship. I'm like,
transparent. Initially, I filed one petition. Initially, I filed one petition, Lordship,
35.
where the private respondents were not made a party because I really didn't know what happened. In that petition, they annexed a mark sheet showing the marks which have been allotted. From there, I found a number of anomalies which have been committed. And so I filed a detailed second petition where I made the present respondent also, the private respondents also a part. Lordship will find and my writ petition.
What is this tender for?
The tender for is house supply of house water connection. Another 6% successful
I
bidder.
think drinking water,
Drinking water, house service
connection is also 5,000. Approximately 30.
Lordship, those 6 have been chosen. The 6 have been selected. The respondent herein who has come before Lordship is the 6th one. My contention is the marking is not correct, and they have taken into consideration marks of a person who really doesn't qualify, which you are not supposed to do as per the tender.
Who does not qualify?
Who does not qualify also to be considered for award. So he doesn't have like one D case, D Singh. And these marks have been taken into consideration and rest of the calculations done. So that is one of my grievance. And rest of the grievance, I say that they have left out certain marks of mine, which I ought to have got. And they also have as a successful bidder people who are registered with the APDCL, PWD, etc., and have serious doubts whether they have ever carried out the work of water connection.
So you say that the marks which should have been awarded to you should be 15.44.
Yes, doctor. My only remark is that let them produce the records of all the marks. Everything will be out and transparent. There's total lack of transparency. So we really do not know what is being done here.
Which department?
Lordship,
GMC.
Urban
Jal
board.
Jal board.
Let them produce the record, Lordship, any day. Even if it's tomorrow, I have no problem.
You have filed your affidavit.
affidavit.
What is your stand?
Our stand is that calculation is made as per the criteria. Right? In the tender itself, the calculation is made. The formula is there. That formula as per the formula, everything calculation is done. And a calculation sheet also has been enclosed.
Where is your affidavit? Affidavit by respondent number 2?
Not
Affidavit by respondent number.
That's one number 2.
Respondent number 2.
not
What did he say? How do you say that why the petitioner has got less marks?
They deny certain work I have done, Lord.
yes, they say that retrofitting should be also be taken up.
No,
As
not
per the-
retrofitting is a part of that.
As per the tender itself,
In the file and claimed that the total marks allotted to the petitioner should be 57.9 instead of 9. Also in difference with that the evaluation was made. Evaluation was made correctly. And Mr. Kaushik, you are appearing for whom?
I am appearing from
The private record.
E. Kumar?
number 8. Respondent number 8.
Who is he?
SS Enterprise Management, who is the 6th bidder. The stay has been
SS Enterprise,
SS Enterprise. The stay is against us.
not to give it to you.
Not
Not
to give to the sick.
Not to
Therefore, it
give
is
to the
referred till the next returnable date notification of the award in so far as the respondent number of the 6th rank bidder, that is respondent is concerned, shall remain suspended.
Ma'am.
What about the others?
others, altogether 30,000 connection will be there. Or
What
each and
others are
everybody will get 5,000. So he is the lowest bidder. Respondent number 8 is the lowest bidder. So they are just pay on the lowest bidder to get the
Lowest means?
Not lowest.
lowest
I am
means
the
lowest
6th.
mark.
Lowest
Says
mark.
I am
lowest
the-
mark.
Lowest.
Lowest mark.
Lowest mark. among all, only 6 will qualify. He gets the lowest.
So 5,000 will be given for 30,000.
In each and every.
So there will be 6 bidders. 6 persons who will be successful.
Selected person.
6, of which 6, he's the 6th. And that portion has been kept out there only because of the fact that if he is not qualified, the petitioner can be accommodated. That's the reason why. So other 5 is going on.
They are getting also.
Now, therefore, the question is between 6th and yeah. So what is the difference between 6th and here as per the marks? Let's see.
Marks
Six
are
has
lots of,
secured 42.65%.
Huh?
6 has secured 42 point.
lots of difference. Dr.
Page 43. And except 5.
Answer for page 43.
Page 43. And what is this SS Enterprise? They have got 42.65.
42.65.
And
Mine is much lower, Dr. Mine is 30.
yours is 28.82, 92.
Yes.
And D. Kumar has been given?
No.
D. Kumar has not been given, but his marks are taken into consideration.
Maybe, but not given.
Not given.
Not given.
No, what
So-
What
lordship
among
is fine.
the, he is disqualified.
Huh?
He is disqualified.
He is
He is
disqualified.
disqualified.
So marks has been given. Marks they have done it.
Marks
It's like a
give-
comparative statement. They do everybody. But
D.
it is a
Kumar-
thing that they not give it. So you have given it to number 1, 2, 3, 5, 6.
Petitioner claims the more
Have you given to AK Construction?
No, my lord. If lordship comes to page number 39, my
page
lord.
39 are the 6 bidders.
6 bidders.
Page 39 of what?
The
Of the
petition.
petition.
Of the report. The 6 bidders are there.
These are the top 6 highest bidders. Marks, they have secured the marks. They have.
Down below.
Consulate. Now, how much marks you should have got
My claim is 52.
as per
57.
you?
As per my claim.
It is 52.
57.
50?
7.
57 you should have got.
And petitioner claims this mark on the basis of the work experience that is done under the Fishery and Tourism Department, which does not come under the work experience as that is described in the 2.1 of the ITB line.
No, that is fishery for house water supply. Fishery.
Where is the terms of the year? 2
Page
point?
32, my lord.
Page 32. Yeah, qualification. How the experience will
My
be.
lord, find serial number 2 work experience. Should have experience of working as a main contractor.
Page
or
30?
Page 32. 2.2.1. Technical evaluation calculation.
Average annual turnover certificate, maximum mark 15. Work experience should have experience and main contractor. House service. What is FHTC?
House service connect.
House service connect.
House service.
FF?
FHTA.
FHTC?
FHTAC. FHTC. House service connection of the FHTC. Oblique FHTC.
30. Value work executed 30. Total years of experience.
Functional
20.
household tap connection. FH.
30. You have a better copy of Annexure 5? Well, how did they pass this document? It's here,
Mine is
Annexure 5.
Annexure 5.
This is the marks allotted.
Yes, sir.
I can hand over that.
Lordship, this is what we got. This is really we tried
yes,
to
sir.
give a best
Better.
copy. We don't have a better copy.
And in page 32, left hand side, the remark, the
Number of
formula is
HTC. 2021. Years of experience, it will be 25. Well, correct, email,
Where is the qualification? Where is it? With art experience. It will be the that after SOTP. But that would
how do you give this years of experience marks? In the case of the petitioner, the experience is for 2 years. Then why have you given 12.5? What is the basis? If it is 3, then it is 18.75. And if it is 4, then 25. So per year 6.75.
The NIT whether that is page number 32.
Yes.
There is a criteria, technical, total years of experience.
Understood.
Maximum
Total
marks
years
is-
of experience, LOA and completed service 25.
Then in the remark column there is a formula. That formula.
Where is the formula?
Yes, madam.
Highest
formula-
value amongst the bidders meeting minimum qualification requirement will be awarded maximum mark weighted mark. If firm A submits highest number of HSC of say 500 among all bidders, marks given to firm A equals to 30. Number by firm E 4,000. No, this is understood. But what about the a year of experience? Why have you made it 6.75 per year? Anything mentioned there?
And
This is only as regards the work experience.
This formula is for calculating the 30 marks in work.
Hmm?
This formula is for calculating the 30 marks in the work.
Yeah. That
For
is why it is only on
NIT
work.
NIT is silent about the years of experience.
And how this in average turnover will be given? Average turnover. One has been given 15.
15. Maximum mark is 15.
15
average
is
term.
given on what basis?
Because in the technical
Average
evaluation
annual
chart,
turnover
serial number 1.
86.1 is given 15 marks.
15 marks.
Whereas the petitioner hearing had average of 21 crore and he have been given 3.70.
Yes.
Then tell me, if that be so, why AK Construction, who has done 18.09, you see that,
yes, sir.
is given 3.15? There's some division, something it has been. Okay, but madam, tell me, how can this court be an expert on these?
No, Lordship, I am not an expert on this. I understand. But they have what I am on that they have to be transparent. It's a public tender. There's total lack of transparency. And my another
No, that question is not of the question of not only Mary of transparency. It is the question as to whether everybody has been uniformly taken into consideration.
absolutely. That's it.
Now, if it has been uniformly taken, just for example, you have been given for 1 year, 2 years, 13.
Yes, sir.
2 years you are given 12.5.
12.5.
And if somebody else is given for 2 years 18.75, obviously then it will be wrong.
Yes,
And
sir.
this court can interfere. But if it is the same yardstick applied for everybody,
No,
then how can we say that it is wrong?
no, Lordship will find for 2 years also someone gets 12.14.
No, 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 no.
24 point.
No, no. Well, 2 years, if
20
anybody
someone
who
gets
has got 2 years have got
24
12.5. Anybody who has got 3 years given 18.75. Anybody getting 4 years is given 25.
Yes, sir.
So it is given at 6.75.
6.75.
Now, similarly, the average turnover, whichever a person is having, I think they are dividing on the basis of the number 1. They are doing it on the basis of number 1.
But on what basis, Lord?
No, no. Whoever is number 1, because there are 6.
Yes.
What I could get it out here, whoever is the number 1, on the basis of that, they are doing it. Just for example, if 86.1 is number 1, and he has been given on average turnover 15.
Yes, sir.
So if you divide that
By what, sir?
86.1 divided by 15 into your amount, that will be how it is being calculated. This is how it is given.
Yes, clearly the formula is there.
Probably.
So that is why. So I think they are doing everything on the basis of the main person, the first one. And after that first one, they are on the base, they are making the basis on the first one, and thereupon they are dividing it, giving the marks on the basis.
Lordship will find,
all the 4 criteria.
the Lordship will find that here, it's at page 43. At, 39. 38, Lordship is specifically written, remarks column. Highest value among all bidders meeting minimum qualification requirement will be awarded highest mark. So, one person who meets all the qualification, minimum qualification you will meet, then your highest mark will be considered, and the rest will be worked out accordingly.
Therefore, if you see at page 32, if firm A submits highest number of HSC of say 500 HSC amongst all bidders, marks given to firm A is 30.
Yes.
Number of firm B, numbers committed by firm B is 4,000. Then what is how it is given? 30 divided by 5,000 into 4,000. So this is how it is done. The same is the application which is being made for all other aspects, making the yardstick from the highest bidder.
But there they have taken D Kumar, this D Kumar as the highest bidder, but highest in one of the for number of years. But D Kumar is not a qualified.
No, forget about there. They are not doing on the D Kumar. They are doing
They've
on
done
this
not
one.
D Kumar also,
Provincial Enterprise.
On D Kumar they did.
No. They are doing on Provincial Enterprise. They
No,
are the number 1.
Not in respect of all. Not in respect of all the values.
No, it is there. Which is the wrong one? Show me.
Lordship, look at D Kumar.
No, forget, don't consider D Kumar. Let us consider only from the yardstick of Purbanchal.
Purbanchal. Lordship,
What
number
is
of
wrong?
If Purbanchal,
Because Purbanchal had 86 as the turnover for the annual turnover.
82.
86.1. 86. And being 86.1 is the turnover.
Yes.
His marks have been given as 15. The maximum marks has been given because it's the highest bidder. And thereupon, what has happened? Anybody who has got 86, this 86, this is being done by 15 divided by 86 into whatever is your turnover, you get your marks. This is how it is being calculated.
Lordship will find, as far as number of years, his marks have not been taken into consideration.
Yes, his number of, just for example, Purbanchal, the number of years is 4. So therefore, he has been given 25.
25.
25. Now, if you divide 4 by 25 into your number of years, that is what is being given to you.
No, Lordship will look. D. Kumar has got now.
Madam, again D. Kumar. Let us
That
observe.
is the big, because
No, that basis is not D. Kumar. The basis of is Purvanchal. Purvanchal is the highest. Because D. Kumar got 62 on the 56. We are concerned with the Purvanchal, who have got 82, who is the highest one.
No, but for other values, his marks have not been taken. His mark has not been taken. I can work out a chart and give it to your Lordship, which will show that for the other total marks is number of years 25. His marks have not been taken, Lordship.
Whose marks?
Purvanchal's mark has not been taken.
The Purvanchal's marks has been taken in
Not in
every
respect-
aspect.
Not in respect of all.
Show me that which is not being taken. Show me the calculation of this. Just for example, let us take into
Lordship,
consideration.
look at page.
He has, see,
Lord-
number of HSC is 5,330.
Lordship, look at page 19 of my petition where I worked it out.
Yes.
Which one? All,
Yes.
all the other categories, Lordship, Purvanchal has been taken only in this category. Which one?
In this
Value
category,
of-
because D. Kumar has 5,477. But
Yes.
D. Kumar couldn't have been taken for the number of HSC because he is not number one.
Value of work executed.
Huh?
The value of work executed. for
Value
Purvanchal
of the work executed is 30 marks.
is 30 marks.
Value of the work executed, value of, yes.
That is, Purvanchal has not been taken for that.
Value of the works executed has to be taken from Purvanchal because Purvanchal is the highest, 26.93.
But Purvanchal has marks given to Purvanchal is 20.
Value of the works executed,
Is 25.
Purvanchal has been given 23.35.
35, Lordship.
Or 30 marks has been given to D. Kumar.
D. Kumar.
Value of the works
So
executed.
Purvanchal-
Oh, no. The value of the works executed. No, the reason is D. Kumar is the highest.
But D. Kumar is not a qualified tender.
So therefore, it couldn't have been taken
Couldn't
into
have been
account.
taken.
So
Couldn't
it
have-
should have taken on the basis of, but how does it affect you?
The entire calculation will be affected
How?
because everyone's marks will become different. And mine.
No, understood, but your marks will further go down only. If it is on, if it is taken, just for example, if it is taken on 50, the fraction which will be there will be higher. But if it is taken on 25, the fraction will be lower. So your multiplication will be different, will be come down only.
No, no, because it will be on 26.93. It will not be on 30 here. The Purvanchal marks being less, the amount will go down. If Purvanchal is taken, this is value is lesser than, so it will go down. That's my respect. And Lordship, my house connection have been arbitrarily.
In fact, then, no, just for example, if we take Purvanchal's thing, then what will happen? Forever D. Kumar, Purvanchal will be then getting
30.
not he has got 30. He will get
30.
additionally another 7, which makes it Purvanchal 90. Because he will get 90.
Yes.
And similarly, it will come down. And it will be on the basis of this. Whoever it has done, 5,300. Whereas your thing, which you have done, is only 1,330.
And Lordship, as far as our house connections are concerned, that also has been
They say that they have not taken the retrofitted,
retrofitting, and they have. I
which
don't
is
know how
not
they
within the
take it.
scope.
It is in the scope. Retrofitting cannot be.
But
It is
how
house
can
of
this court say that yes, retrofitting has to be
No,
taken?
And Lordship will say one more thing. Lordship, I am saying the first few numbers, first two people, they are registered. We do not know. They are registered with APDCL and PWD. Obviously, they do electrical works, etc., etc. The tender says that it has to be registered with some government department, whatever.
Hmm.
We do not. We have with a specific allegation. They do not have experience in water connection.
You don't have.
They do not have. The first, the Purvanchal, etc. Purvanchal does not have. Purvanchal and
How they have done HSC? HSC is what?
household connection.
House.
how they have given that is
House
the
service
one.
connection.
What
That
is
is
this
the-
house service connection of what?
Water.
Water. Then how do they have 5,330?
Yes, they have it.
they had given their documents for the showing that they have transformer connection.
That is what I wanted to see. I want the records for that. We do not know. We have serious doubts.
Okay.
PWD, I have serious doubts. PHE, we don't have anything because they do that work. APDCL definitely doesn't do that work. APDCL definitely doesn't. They do not let us know who are the technical members. It's not necessary. Who the tender committee.
You have the
members.
records?
Right.
Where is it?
Next week, my lord.
No, not next week. Records? She only wants to see.
I want to
The
see.
case is going in your
Lord
favor.
will not pick it tomorrow or next week, any day. I will get hold of it.
Okay.
Let it be week after next day.
No.
Week
It will
after
be on 28. 28.
28.
28.
Yeah.
We'll have it on 28. On that day, you will dispose of the matter.
Yes, Lordship.
Only thing is, you just show it to her satisfaction.
Lord.
Let me see. And Lordship,
Nothing
I don't
more.
have a case.
And in fact, you calculate one thing. You give us a chart. I ask you to prepare one chart, taking into account the highest one and not the disqualified one. And what would be the mark? Would that make any difference? Because for me, I don't think they would make a difference. In fact, the marks of the petitioner would come further below.
But if it vitiates the entire thing,
Huh?
it will vitiate the entire thing.
So only satisfaction is for madam to look into it.
Well,
Fair enough to say, if I find that everything is ordered, I'll be the first one to place it before your lordship.
Lord, that
We'll have it.
Lordship,
On 28, just produce that. This is a matter on 28 for the matter has been duly heard. However, before concluding the hearing, this court finds it relevant to have a perusal of the reports.
Lordship, let it be fixed at 2 p.m. Lordship.
List the matter on 28/11/2023 at 2 p.m.
Obliged.
Hard in part. And you make the charter.
Lordship, definitely.
I'm not recording it, but you
Lordship,
make a
Lordship.
check. Remove that person, E. Kumar, and how much it would
How much?
Obviously, it will come. The Purvanchal would be much more.
The petitioner will not come within the zone of 6%.
Huh?
Within the zone of 6%. It will not-
No, the petitioner would not, but petitioner's
change
value
the
would
detail.
come down. So let her also have the satisfaction. Yes, you got it.
Yes, sir.
Yes.
Lord, I still pray, my lord, possible decide the two decisions or two clause,
Which one?
which I have just.
No, not this. Mr. Das,
so.
we will decide on a day when this clause becomes relevant. If they are not going ahead with the tender, why should I?
Both the clause, but
Huh?
my submission may be recorded so that.
Now, I will say
Yeah.
that the petitioner, the dismissal of the instant petition as infructuous shall not preclude the right of the petitioner to challenge such similar clauses if they are in the tenders. Which one has become infructuous? 6039.
Yes.
No, I got confused.
Huh?
Yes.
Mr. B. Didas, the learned senior counsel.
The second tender.
Okay, senior counsel appearing on behalf of the petitioner submits that the instant writ petition has already become infructuous and as such would not like to press the same. Accordingly, the instant writ petition therefore stands closed or as it has become infructuous.
Because of the retendering.
It's okay, that is infructuous. 6637 of 2022. The instant writ petition has been filed challenging clauses 4.8 and 13.1 of the notice inviting tender bearing number 10/2022 dated 11/8/2022. Today, when the matter has been taken up, Mr. P. Sharma appearing on behalf of the AFDC,
Lordship.
AFDC,
Yes, okay.
submits on instruction that the office, the AFDC, Assam Fisheries Development Corporation Limited, is not going ahead with the said tender and would be issuing a fresh tender. Taking into account that the said full stop. In that regard, an instructions have been placed before this court, which is kept on record and marked with the letter X. Full stop. In that view of the matter, as the respondent authorities are not going ahead with the said tender, the question of deciding the fate of clause 4.8 or as well as 13.1 of the said tender which have been withdrawn does not arise in the instant case. Mr. B.D. Das, the learned senior counsel, submits that the respondent authorities have been issuing similar and had submits that this is the third tender. And every time, in view of clauses and in view of clause 13.1, the respondent authorities are going for fresh tender. It is the opinion of this court that as the said tender notice in question have been withdrawn by the respondent authorities and they are in the process of initiating a fresh tender process, liberty would be always there. Liberty would be there to the petitioners if to approach this court in the eventuality that similar conditions are incorporated in the fresh tender. With the above, the instant petition stands disposed.
Obliged, Lordship.
Stop the purpose.
Eh?
Have our
Stop
purpose
the
also.
purpose of-
Start our purpose also.
Interim orders, if any, stands vacant.
No, there is no interim.
Item number 2, daily.
Please, my lord. Herein we had circulated an adjournment slip yesterday, my lord.
Oh, they?
The respondents 4 and 5. My lord.
You are 4 and 5?
Yes, ma'am.
Okay. Where's the petitioner? Okay, that is why they are not present. Oh, sorry. Matter pertains to?
My lord, there is a dispute regarding land. My
They say that there's a piece of land which is a road and there's a blockage on that road. They cannot
call
use.
it to why the respond number 2 and 3 not be there to for removal of the equal illegally and unauthorizedly constructed by private respondents. Thank goodness. If the private respondents have constructed, what is the business of them? File a suit for mandatory injunction. Dismiss. None appears on behalf of the petitioner on call. This court have duly taken note of the reliefs which have been sought for in the instant writ petition. From a perusal of the said the relief which has been sought for is that the respondent numbers 2 and 3 should demolish the wall constructed by the private respondents, numbers 4, 5, and 6, in is it in the public or road they have constructed?
Yes, Ballot.
That's the allegation.
That
That
we
is the
filed an
allegation.
No, what is your stand?
our stand, Ballot, we filed an affidavit yesterday. It is a road, Ballot. There's a on that road. at
Public
one end-
road?
Yes, Ballot.
Tell me.
My lord, we have not got a copy of this.
Forget about that. Is it a public road?
My lord, our allegation, our contention is that it is not.
Absolutely. Then show me your land.
No documents, Ballot.
What business you have to construct on public road? demolish.
Lordship, let
Rightly.
me kindly allow us to take a copy of this affidavit and
Have a copy? Yes.
And-
Now tell me.
kindly fix it on another date, Your Lordship,
Oh,
because
why?
Lordship, Mr. S. Bhattakur appears for respondents 4
So
and
what?
5, my lord, but he's out
I
of
don't know.
station today.
That is not the, but how can you construct on public road? Wall? Brick wall?
Lordship, may fix it on Tuesday.
Locked gate
I
on
don't
one
have-
side and brick wall on another.
Huh?
Locked gate on one side of the road, brick wall on another.
My goodness. Public road constructing too much.
Or receive. Right. Receive. Not yet.
And why is this matter on a Tuesday, Thursday? This matter is to be taken as the first item on a Monday, Tuesday.
But-
Don't require anything to be looked into. Ms. S. Sharma, the learned counsel appearing on behalf of the respondent state submits that that an affidavit has been filed by the
Respondent number 3, my lord. The clock.
respondent number 3, wherein it has been duly mentioned that the wall so constructed by the private respondents is on the public road. This court made a query upon the learned counsel appearing on behalf of the private respondents as to under what basis they have constructed a wall on the private road. The learned counsel seeks for an accommodation to list the matter as the first item on 29th.
Much obliged.
Item number 3.
Yes.
A bonded warehouse, my lord. And since 1998, in the year 2016, my lord, I found that many items had got sedimented. So I applied to the superintendent of excise as to for its destruction. The superintendent of excise wrote the letter to the commissioner, got the approval. Thereafter, chemical examination was done. It was found that it has become non-consumable item. And thereafter, destruction was allowed. The amount of levy was waived.
Yes, what is your basis?
Lordship, we have submitted an additional affidavit
I've seen it.
stating that there is an objection by Auditor General
For what?
saying that remission on destroyed stock should not be allowed because there is Rule 32 under the older rules. Because this stock was destroyed before the new rules came in, therefore the old rules will apply. In old rules, Lordship, Rule 32 is there, which says that the state government will not be responsible if the stock is damaged by whatsoever reason.
How does this apply for you to impose upon him this 36 lakhs?
Because it's a bonded warehouse, Lordship.
Earlier, bonded warehouse, there was no question of tax or excise duty. That is the specialty of a bonded warehouse. It became thereupon, what is the difference between a bonded and a warehouse and a normal warehouse? The normal warehouse is that after the payment of the excise duty or the tax, it goes to the retail warehouse or the normal wholesale warehouse. Otherwise, it is the bonded warehouse. The basic definition is that there is no question of tax or excise duty.
Lordship, if we look at the very word bonded, it means that the stock, when it's in the warehouse, there's a bond as to the duty shall be paid.
Where? On the when the goods are really taken out.
Yes, your Lordship might be referring to Rule 41 and 42. Lordship, it only lays down the manner of payment. It does not lay down.
What is the difference between? It's seen in 2016 rules also, 2000 Act also. It makes it very clear.
Lordship, it only talks about the manner of payment of duty, but the liability.
What is the difference between bonded warehouse and a wholesale warehouse? Tell me.
Wholesale, Lordship, the duty is already paid. It's prepaid. So
Absolutely.
after that.
And what is the bonded warehouse?
It's not paid because there's a bond to pay the duty on that stock. Yes. There is a bond to that stock and it will have to be paid, Lordship. And when licenses are granted to the warehouses, it is a part of the bond condition that on notice, it will have to be paid, the levy and the VAT. And this section, Lordship, that was referred, 41, payment of duty, it is sort of an obligation to the warehouse that when it leaves the warehouse, it will have to be paid.
But it didn't leave. It was given on the basis of your permission. It was destroyed.
Yes, destroyed without the fault of the government. Due to some of their own business decisions, it had to be destroyed, and permission was granted because it is a matter of public safety.
Permission was granted because you are, as per your affidavit, quantity was allowed to be destroyed.
Yes,
and was destroyed on the so and so. You have allowed because you say that it is submitted that a quantity of so and so real of sedimented inferior quality of old stock of beer was lying at the premises at so and so. The said quantity of beer was allowed for destruction because of that.
Yes, it was allowed.
Then why will they make any payment?
Because Lordship, they still had the bond to pay the duty. Because if your Lordship sees the very nomenclature of this act, it says bonded warehouse. It means they have a bond to pay duty on whatever stock that enters their go down.
Show me that. Where is it? And the right to payment, when it will be at what time it will be liable to be payable?
Lordship, there's section 32.
A licensee of a bonded warehouse who have imported or transported liquor other than under bond for payment of duty shall pay to the government duty prescribed based on the country license. Now, what do you say about 43?
That lordship talks about
Then-
destruction,
Then how, where is the question of payment then?
but it's lordship, it nowhere mentions that the tax duty will have to be remitted. And if your
No,
lordship,
no, are you saying that on one hand, you know that it is inferior quality,
Yes.
you know that it is sedimented beer, but then also they have to pay for the bond? It can't be.
yes, lordship,
Because if you see payment, manner of payment of duty, how it is to be paid. When duty on a spirit is to be paid before removal from the bonded warehouse, the payment shall be made into the local treasury or a treasury approved by the collector or the district in which the spirits are to be sold or consumed by direct payment into the treasury. Advance deposit on account of duty may also be made with the permission of the collector. So it will only when it is removed from the bonded warehouse. But when this provision is there, 43, if spirits stored in a bonded are found to be inferior quality or otherwise unsuitable for the purpose for which they are stored, they may be rejected or destroyed or otherwise dealt with under the orders of the excise commissioner. Now the excise commissioner gives the permission for destroying. So matter ends.
but that is what lordship,
Then why will they make payment?
lordship, rule 42 and 41 talks about how the duty has to be paid once it is allowed
Understood.
to
But
be.
when it is allowed, when it goes for sale
Yes, but
or for consumption, you see this payment of duty, the duty imposed on foreign liquor imported under bond or stored in the bonded warehouse shall be paid before removal from the bonded warehouse unless a bond has been executed for that purpose.
Yes.
So before removal. Now,
Yes.
did they execute a separate bond? No. Obviously, no. Manner. When a duty on the spirit is to be paid before removal from the bonded warehouse, the payment shall be made into the local treasury or the treasury approved by the collector of the district in which such spirits are to be sold or consumed by direct payment. So
Yes.
this is how the manner of payment will be there.
Yes.
Now, if it is not sold or to be consumed in that district, how will you affect the payment?
Yes. So, lordship, both these rules are only talking about the event where it will be allowed to be sold and taken out of the warehouse. Here it is unfit, so it won't be allowed to leave the warehouse. It will have to be destroyed, lordship, because it's unsafe for.
And there is a permission being
Yes.
granted.
Yes. Now, lordship, will have to see when do the tax liability actually arise, because now it's a situation where it cannot leave the warehouse and destroy it. It has been destroyed. So their liability arises right from the moment, lordship, they enter the warehouse.
No, it can't be.
If your lordship looks below in that page,
Uh,
the conditions of the licenses are listed below 43, lordship. And there it says that
which condition?
Condition 9, lordship. It says that he shall pay on demand for all foreign liquors and spirits deposited and stored thereon. So, lordship, there is always a right to demand that duty, lordship, which was.
How can you demand when there is nothing? You have allowed them to destroy.
Because, lordship, it's an indirect tax. And
no, where is the question
Yes.
of indirect tax? Whatever
Yes.
may be, you
Yes,
are taxing on a commodity which is no longer for sale, which is he has not consumed,
Yes.
which has not been consumed, it has been destroyed as per the orders passed by you.
Destroyed, lordship, because it was unsuitable and because of fault not attributable to the government.
So are you saying
Yes,
that the
Lord.
moment any bond,
Yes.
any materials enter to the bond,
Yes.
irrespective of anything, you have to pay the excise duty?
Exactly, lordship, because this is an indirect tax that is to be set off against the manufacturer also. Since it's an indirect tax, the burden can be shifted on the warehouse owner as well. And warehouse owner is actually the point of collection of VAT and levy. And therefore, yes,
VAT, understood.
Yes.
But VAT will be on the basis of a sale.
yes, sale that has taken
Unless,
place.
no. If there's no sale taking place, then where is the VAT?
Lordship, from the manufacturer to the warehouse owner, a sale has taken place, lordship. That's where the VAT and the levy are arising. And lordship, that forms the basis of why the audit is objecting, lordship, which I have attached in the additional affidavit.
Because they purchase, the bonded warehouse purchases.
No, Lordship, because their duty should not have been remitted. Yes.
I'm asking, does the bonded warehouse
Yes.
purchase the goods from the
Yes.
manufacturer?
Yes, Lord. That is the transaction which
So
becomes
the-
taxable.
From the manufacturer, it comes to the bonded
Bonded
warehouse,
warehouse, yes.
and they become the owner.
They become the point of tax collection. It's
No, are they the owners of the
Yes.
property?
Yes, Lord. They are the owners of the liquor.
They are not holding it at bond for others.
They are holding it on bond for government to pay the duty for that liquor. The bond is with regard to the duty, Lordship, not with regard to the liquor.
How do a person gets into the bond removal of period? How do they bring the Rantola on receipt of an application and after inquiry they accept the court application? The opening of a bonded warehouse and the people in Yes, Mr. Singh, how do you bring the goods
My lord,
from the
my
manufacturer?
brother is getting confused with VAT and excise duty. Let me first clarify. I am talking about only excise duty, and that has only been waived. So for other revenues are concerned, the letter, the annexer kindly come to annexer 15, my lord, page 44. What has been waived and what has been not levied.
Page 44.
Page 44, my lord, annexer 15.
Ah.
This is the letter of the commissioner, my lord, dated 30th of August 2016. Kindly come to second paragraph. Therefore, subject to as objection by audit, total excise duty involved on the above sedimented stock of beer against which no revenue is forthcoming, total amounting to rupees so and so, is hereby remitted as per instruction number 229 relating to liquor under Assam Excise Rules 1945 on the excise duty. Next line, my lord. The import fee, transport fee paid against the destroyed quantities of liquor shall not be adjusted with future transactions. So whatever I have already paid as import duty and transport duty, my lord, that won't be adjusted. It is only the excise duty. Now kindly come to section 2 of Assam Bonded Warehouse Rules, my lord. Your lordship was asking as to who is bonded warehouse and what does it mean?
No, that I've seen it. I've seen that. It means that without duty. No, I'm asking you. No, Mr. Singh, kindly please. I'm asking you, how do you bring the goods to your place?
From the manufacturer.
How? You purchase it.
Purchasing by paying import duty and transport duty.
Do you pay the excise duty?
No, excise duty is to be paid only if I remove from my bonded
Understood.
warehouse.
Understood. But did you pay the excise duty? No,
my lord.
you
That was
don't.
not now it is
Only for the purpose of removal.
yes.
But the sale which have been made by the no. Only a bit. You see, who is actually liable to pay the excise duty?
Until and unless, my lord, it is sold out and is removed from the bonded warehouse outside the bonded warehouse premises, my lord, there is no question of deviation of any excise.
No.
That was the rule, my lord.
No, Mr. Singh, kindly. There's a marked difference between two aspects. One is a case of charge and one is a case of collection. The point of collection may differ. The charge is on where? The charge is on the basis of a sale being made by the manufacturer to you.
That is applicable in case of sale, that the sales tax is applicable, which is now known as VAT. But so far excise duty is concerned, earlier the rule was that until and unless it is removed and sold for consumption, there was no question of levying any excise duty. After 2016 amendment, the rule has changed.
Where is it? Rule?
I am talking about the earlier rule, my lord.
Now let us see. I am only looking into means the premises or any part of the premises approved and licensed for deposit or storage of on which the duty has not been paid.
The duty has not been paid. And
so are you saying, therefore, if a particular batch of beer is being manufactured by the manufacturer and he brings it outside of his inventory, he will be liable for central excise? It's different. There would not be a state excise when it enters the SAM?
No, there was no question of leviation of any excise duty from at the end of the manufacturer. The moment it comes, because the process was, it has to be sold through bonded warehouse. So manufacturer cannot directly sell it to the retailer. So it has to reach to a bonded warehouse where from it will go again outside. And who was to main the bonded warehouse, my lord? It was always a state government employee. May I take your lordship attention to 2-3 more provisions, my lord? Kindly come to. Your lordship has already seen rule 2, section 2. Now kindly see who is to main, who is to look after, who is the main boss, my lord? Section 7. Assam Bonded Warehouse Rules 1965. The Commissioner of Excise shall appoint such excise officers and establishment as he thinks fit to the charge of the bonded warehouse. The licenses shall pay to the state government at the end of each calendar month such establishment charges as may be determined from time to time by the Excise Commissioner. The cost of establishment shall include pay and allowances, if any, as well as leave salary, pension, and contribution. So the officer in charge, who is appointed by the government of Assam to look after the bonded warehouse, is a government employee. I am to pay the salary. So that was the rule, my lord. So ultimately, the ownership remained with the government. As a licensee, my lord. May I take your lordship again?
Mr. Singh, these type of submissions kindly don't make. Those type of you kindly tell me only one thing. As regards the point, where is the charge? The charge of the excise, where it will be.
So
is the submission you make.
Rule 41, my. And
you make a submission, yes, unless and until there is no consumption, the question of imposition of excise duty does not.
What is the word used? Removal. Yeah. Twice it has been used, my lord, the word removal in Rule 41 and Rule 42. If I can read, my lord.
No, I think we may have to, we may have to look into the Excise Act 1910 with the power to impose. The excise duty will be there under the Act, not the rule. Where is it?
Lordship, as far as I have studied, the Principal Act only talked about the rule-making power of the state government.
No. Doesn't have the power to levy.
Yes, of course.
The
But-
levy, where is the power to levy excise?
It comes from the Principal Act.
Where is it? You say, you may make a submission that, okay, that unless there is a consumption or being sent for sale to the district, the question of making payment, the excise duty cannot be levied. That is a fair submission. But don't make that.
My lord, okay, my lord, may I give another submission?
You show me the power of levy.
Levy, my lord,
Power of, how the power of levy. Do one thing, both of you prepare yourself on that aspect. The power of levy.
power of
Where is the power of levy and what is to be levied? You see, one thing one has to understand in the case, excise duty is what? Excise duty is a form of taxation.
Yes.
Now, one is the power. Who has the power? This government. Number two, where the power is to be exercised.
Yes.
That is the subject.
Yes, a Lordship.
Number
Act of-
three
yes.
is the point. Point may change. Point may go here, there, whatever may be changed. But the fact is the power and the subject. Whether the subject can be taxed if it is not worth or if it is destroyed.
Lordship may look at 21, section 21 of
Excise Act 1910.
1910 Excise.
Duty on excisable goods. Any duty on or countervailing duty as the case may be at such rate or demand may be imposed either generally or for any specified area on any excisable imported, exported, transported, manufactured, cultivated, collected under any license granted under manufactured in a brewery or license provided as duty shall not be imposed on any article which have been imported into India and which is liable to be imported. Duty may be imposed for this section at different rates according to the place in which the excise are to be. So this is the subject.
Yes.
Power is there and you have the subject. The subject will be on the question of moment on any excisable article. So the moment it is imported also, it can be done.
Yes.
So your submission therefore is, we have not asked them the money because they were under a bond. Once the bond is there,
yes,
they may ask the money back from the authority, those manufacturers that they gave inferior quality. That's a different thing.
Lordship, that will be reflected in the price, and that's how indirect taxes function. The manufacturer will price his good accordingly, and the warehouse owner will buy it in a way that once he resells it, he can set off the.
But why after 41, 42, 43 has been giving a permission to the excise officer? If they have to pay, why do they have to take the permission? Tell me.
Yes, because as to the unsuitability, a
If it is
verification has to be.
unsuitable, why do they need to take a permission? They can destroy if it is their property. And anyhow, if you say that they have to pay, then why do you have to take your permission?
Yes. In fact, Lordship, to remedify that situation, the new rules have been brought into force.
Understood.
Yes.
But if the rules are not proper, then how can you impose upon them?
I'm not saying, Lordship, that the rules are not proper, but of course, Lordship, it causes.
On one hand, you are saying that rules are not proper, therefore you are coming to this. But the question therefore is, here is, if there why there was a requirement of having Rule 43?
Lordship, it's a protocol to ensure the safety of the public, because that's how the government will ensure that no unsuitable liquor leaves the warehouse.
Control structure.
Yes. And if your lordship looks at the language of Rule 41 and 42,
You can very well restrain them from selling, leaving, but why do you give the permission for destroying?
just
You never know. They may keep it there. Why do they need to? You give a permission to destroy, and then thereupon you impose upon them the excise duty, but you have to pay.
yes, lordship, because firstly, one of the purposes that it serves is that the state is put to notice that this stock is unfit.
No, understood
Yes.
very well. Okay.
Yes.
But the fact that you give the permission to destroy,
Yes.
you may say they don't. You can't remove unsuitable goods. It's a different thing. But why do you need the permission for destroying?
To check the issues of tax duty evasion.
Huh?
There might be some duty
You can.
evasion
You
in the name of-
obviously have it from the fact that when it was brought, and you have your officials as per section Rule 7.
Yes. But lordship, in fact, there's a batch of matters that is listed before your lordship's court. There, the issues with regard to payment of non-consumable stock, and what they're essentially challenging is that the amount of non-consumable stock that has been quoted in a notice is lower, and they actually had more amount of non-consumable stock.
It is a different thing.
Lordship, the only reason I said this because it shows how convenient it might be to avoid the duties if this permission clause
That
is
was
not-
a case where the excise department specific allegation is that, look here, those people who have made that inspection at the time, that relevant point of time, they have not done it properly. And thereupon, when we made the inspection, we found that there were huge quantities of stocks lying out there, and they have paid a very less amount of money. And therefore, you have initiated, for which I had set aside, giving you again the liberty to take action.
Yes.
I remember that, but I'm not on that. But I'm asking you a specific question. How do you bring 43? How do you reconcile 43? Because on one hand, you give this, because 41 and 42 only say that on the question of removal. Understood? 21 says on the question of import also you can do it. But why do you need to give a permission for destroying? And why do they have to ask the permission? Very well, you can very well say you can't leave it. But why do you need a permission for destroying?
But a lordship can also
And,
take-
and that too when it is not fit for use.
yes,
So
that
the
is for
question
public
is
safety. Yes.
as to whether you can impose the excise duty the moment it is brought within a SAM,
Yes.
or is brought
Within the-
transported within a SAM, then it becomes a charge for payment of excise duty. And they are not paying because they are holding to it.
Yes. Lordship, from what I could understood is that the bonded warehouses are essentially the point of tax collection here. And once it enters, that is when the bond to pay levy on that specific stock starts. And in fact, Lordship, when the stock enters the bonded warehouse, there will be excise officials who would be measuring that thing, but the tax will
Not
not
only
be
that,
there.
at the time of destroying also, the excise officials will be there.
Yes, Lordship, will have to be there.
There.
That is true,
So
Lordship.
they will also look into, yes, there is a destroying. The excise officials also will see that they are fit, non-fit, unfit liquor is not also brought out.
Yes.
That is why.
Lordship, that is to ensure again public safety and avoiding evasion of taxes. That are the two principal reasons why this has been laid down, Lordship. And Lordship will also have to take into account Rule 32, which says state shall not be responsible for any damage or destruction to
Out of
the
fire
or any cause whatsoever.
whatsoever,
Yes.
but that has nothing to do. Even if when 39 is there, why is 43 there?
That is so that the state is put to notice once this process
No.
of
The
destruction.
state
Yes.
shall. Are you saying
Yes.
that You are bringing 39 on the basis that look here, we have give you the permission, whatever may be,
Yes.
but then also we shall not be responsible. You have to still pay the excise.
Yes.
That is what you are saying. But that has nothing to do. 39 cannot be raised into 43. Not possible.
If Lordship looks at the entire act harmoniously and the fact that it is called bonded, which it is no longer called after this new amendment.
Yeah,
Yes.
because 43 is a very important thing which permits,
Yes.
which requires, and more particularly the words used out there, when the liquor becomes unsuitable, it
That-
becomes nothing. But the only concern, therefore, is as to how do you take care of 21, section 21. And when they have purchased that liquor from them without payment of excise duty, we'll hear further. The thing you have to address on this aspect.
My lord.
You have to address this code on this aspect. How do you take care of 21? Because 21 puts the bar, imposes that any excisable article would be liable to payment of excise or levy, or would be levied on being imported, exported, transported. And being so, even if assuming 43 is there, permission has been granted, how do you reconcile that you have purchased the goods from the manufacturers and that must be the remedy why now they say that the bonded warehouse still do not require and has made the bonded warehouse and the manufacturer one and the same.
Yes.
So then the question of purchase does not arise.
Yes.
That is the reason I think why 2016, this is the basic idea. Hello. Third in part, this is the matter again on January. January when? Then 10th of January. Yes, any important matter?
Item.
Yes, Mr. Sharma.
Then compensation.
Oh, that instruction has come.
My lord, we need some time, my lord.
Why? Only two cut
my-
out 16
my-
letters of land.
My lord, because records, my lord, could not trace out. So we need some time, my lord. 4 weeks was paid, my lord, last week.
How
my lord.
much? When do you want it?
In the month of January, my lord.
January is too late.
Because
The whole matter.
my lord, that's why, my lord, they are,
Then
my
look
lord, trying hard, my lord.
No, January, if I fix it, it's too long. Then they will go to sleep. We'll fix it again on 11th of December.
But-
Try to get it.
Lordship.
Miss Yudas, the learned additional senior government advocate, submits that pursuant to the directions passed this court, the respondent authorities are trying their best to trace out the records pertaining to as to whether the compensation in respect to the portion of land have been paid to the petitioners. She submits that the state records for the unpaid compensation of the land acquisition proceeding, the state records have not yet been, could not be traced out till date, taking into account that it is a very old matter. List this matter again on 18th of December 2023, on which date Ms. Yudas, the learned additional senior government advocate, shall ensure the receipt of the instruction.
My lord. Oblige.
I beg to mention item 7 and 8, my lord. There's a stay in operation, state is losing revenue. So my lord, may it be fixed on 12, my lord.
At the request of the learned counsel for the
Forest Department.
Forest Department, who submits that there is a interim order operating and thereby the Forest Department is losing interim order operating and has expressed urgency in the matter. This court fixes the matter again on 12th of December 2023. Interim order passed earlier shall continue till then.
Item number 40, my lord, that will be taken up on 6th of December.
So then what is that?
That is that, my lord, Tezpur municipality tender matter.
indicated
my lord.
yesterday that it will be taken up at 2 today, but the list does not reflect that taken up at 2 p.m. That physical, disability, the tender was awarded on the ground of alleged disability.
Oh,
There is some urgency and there is an interim order also.
the request of the learned counsel for the parties. And due to paucity of time, the matter could not be taken up, for which the learned counsel for the parties submits that the matter be taken up on 6th, on 5th of December.
6th,
2000.
6th.
Why 6th?
5th, I'll be out of station.
So,
Like taken before that.
okay, before that,
No, my lord, I'll be out of station. I'll not be here
from when?
from tomorrow.
Well, ask your junior to be paid.
My lord.
On 7th of December 2023. Interim order passed earlier shall continue.
Item number 9. I have some urgency. I have paper date. Item number 9.
What is there?
So any date, it's the first week of December.
What is this?
Appointment of arbitrator.
Appointment of arbitration petition.
Yes.
11-6.
Yes.
Then you dispose it of. Right. 11-6, what is it?
Monday.
Who is the other side?
Lordship, I am appearing on behalf of.
Are you
Mr.
opposing?
No, Lordship. Today, Mr. Arkiti Chaudhary is not here. Mr. Arkiti Chaudhary is not present today. Lordship,
The
may
appointment
after.
of an arbitrator.
Yes, Lordship.
Where is that? Where is the clause?
Clause page number, Lordship. Page number 114. Clause number 7.
Yes. Clause number 70.
Clause
All
70.
disputes between the parties to the contract, other than those for which the decision of the CAWE or other persons is by the contract expressed to be final and binding, shall the written notice by the parties to the others that be referred to the opinion. The inferior officer to be appointed by the party mentioned in Yes, then what happened?
Then Lordship,
No, this is a petition under 11-6
11-6.
because it cannot be done nowadays after the fourth schedule. Oh no, after the second schedule of what it is required. No, 12-8 or what is it?
12.
The same party can't be there, na?
Yes, sir.
Huh?
12, section 12, subsection 5.
It can't be there now.
Yes.
So there has to be appointment of somebody else.
Somebody else.
Okay.
This is what Lord respondent is insisting on.
Huh?
They want an arbitrator from their.
You also want.
No, they want. We are opposed.
Oh, it can't be done in view of the Perkins judgment. Perkins?
There is a section 12, subsection 5 also says that.
You say that the arbitration is there,
That is it.
that the dispute is arbitrable or not.
Yes,
But the question is,
regarding appointment.
you are going to appoint.
That's what.
What is this? What is your stand?
They are insisting on a list prepared by them.
Huh?
They are not opposed to the appointment of arbitrator.
Where is? And they say that you have not done it. You have not filed the application in a proper manner.
Subsequently, I filed it, Lordship. It's on page number 325. It's the last notice, Lordship. They have sent it. They wanted me to address it to the engineer in chief. I have accordingly addressed it.
Yes, what do you say?
Lordship, our reply is there in paragraph number 2021, Lordship. Page number 347, 348, Lordship. We have also filed additional affidavit.
My understand, I'll one affidavit, Lordship.
You have filed no? Additional affidavit.
Is the affidavit filed by the respondent. Para number 23.
Yes, I read it. Where is that list, annexure 13? That annexure is not there.
It is not there with the affidavit. My copy of it is there. In my copy of it is not there.
Annexure 13 is your list.
No, it is a list. It's a affidavit filed by the respondent.
Hello, we'll take it when he's there. Huh?
Yes, Lord.
Will require. I think the judgment in Perkins is clear, na? That judgment of the Supreme Court
Regarding
is specific that they cannot appoint.
regarding it, the professor on 12 on Sanchez. Supreme Court. There is a judgment of Supreme Court. There's a three judges then. So their issue of appointment of retired officer was that was the issue. Whether a retired officer can be appointed as arbiter. And subsequently the judgment was referred to larger bench. And now the before the 5 judges bench, the issue is pending. But my case is the appointment to a serving officer here in my case. But in the Supreme Court, the issue is the retired officer. There is a central organization for railway electrification. In that case, that is it was held that even retired officer can be appointed as architect. But subsequently, in Zontia Constructions,
No, these judgment was delivered on the basis that 12.5 would not be hit on the ground that there is a panel of arbitrators from where it can be chosen. You have still an opportunity. That is the reason why that was the justification given by the 3 judges. And thereby said that Perkins is okay. Perkins, or there is another judgment of the division bench, I think it's okay. But the only thing is, when there is a panel and the panel is being forwarded, they can very well be appointed. That is, I think, the judgment. 3 judges. By who was the judge who wrote it? The judge, it is there.
I had the petitions. I'll go for the.
Hello. We'll have it list the matter again on 4th of December.
Okay.
Okay, any urgency? No.
Item number 10, there is an interim order operating in my favor. It relates to the settlement of the market. Private respondent was settled with the market, your lordship. Admittedly, in the interim, it was observed that he submitted some fake documents and he obtained the market. And therefore, there was an interim order which was passed. So may I pray that the interim order is still today and can it be taken up?
And for the main respondent number 7, my lord, the settlement order, there may be fiction next day, matter, because trading is complete. It can be there, but it can be fiction on next day.
When?
Like 28 or 29.
We'll have it on 12th of December. This is the matter on 12th of December. The interim order partially executed.
I'm appearing for BTC, Your Lordship. Respondent number 234.
I'm for main respondent number 7.
Give your name. DP
of that.
Today, the whole day I was busy with electricity. First half has gone just with electricity.